Yes.
So I beg to mention for listing for motion lordship on criminal fiction lordship. I file on 11-1 lordship.
When do you want?
Can it be list on the 22nd lordship?
Okay.
Of that.
May I please have a-
Yes.
I'd like to mention for bail application on tomorrow, similar matter already listed on.
Tomorrow may not be possible.
Similar matter already.
Maybe. We have to pass the order. We have to go through the record. Don't insist. If there is no, no. Monday.
Please, Your Lordship, I beg to mention for listing of a bail application, Your Lordship, on 29th or 30th. 29th. May I please, Your Lordship? Lordship, I beg to mention item number 4, Lordship, on today's motion, Lordship.
Yes.
Can it be taken up after a week, Lordship? Item number 4 for motion, Lordship.
Mr. V.S. Sodori, learned counsel for the petitioner. Price for listing the matter after a week.
After a week.
Okay. Pair alone.
Highly obliged.
I beg to mention item number 14 lordship. I may be allowed to withdraw this. As per the instruction of my client.
When?
Lordship.
Which matter?
43 item number 43 lordship.
Okay.
Lordship, I beg to mention criminal appeal number 120/2023. Item may be listed 25th of January, Your Lordship.
Okay.
24th.
24th. 24th?
Next.
May I please, Your Lordship? Lordship, I am praying for listing of a criminal petition, my lord. Any day of next week, my lord.
Any day?
Next week, any day.
Okay.
25.
Please, my Lordship. My Lord, bail application filing number 546 of 24 may be taken up today along with the item number DL number 59 of 59. That is the another co-accused bail application. Your Honor.
Madam, you see, today we have more than 57 matters.
Your Honor, that
59
bail
matters.
is fixed for CD today.
Pardon?
Your Honor, bail application number 124 of 24 is fixed for CD today. And we are the co-accused of.
Okay, see, we will retain the CD.
May I please, your lordship. I am praying for listing of a criminal petition lordship.
When?
On 22 lordships.
Okay.
Another prayer for item number 12 may be taken.
Today's list.
Yes, lordship. May be taken after a week, your lordship. We need some time to.
Item number 12.
Yes, lordship.
Yes. On the pair being made by Mr.
S.A. Borboya.
S.A. Bormuya, learned counsel for the petitioner, list the matter after a week.
Deeply obliged.
May I please, Your Lordship? Lordship, item back. No, may I please, Your Lordship? I beg to item number 14.
Today's list.
14. My senior auto history.
Item number 14.
This matter pass.
Your good name?
Islam.
Pardon?
Islam.
Islam.
Your name is not there in the cause list?
Lordship.
After.
May I please, Your Lordship?
Acha. On
I
the,
beg to mention item number 14.
yes,
For pass over for the day.
on the
My
pair being
senior
made
auto petition
by Mr. A. Islam, learned counsel for the petitioner. List the matter when?
Any day, next week.
After a week. Okay.
With the consent of the other side, I beg to mention item number 11. Kindly adjourn this date.
Your good name?
KM Bora, respondent number 2.
Mr. K. M. Bora, learned counsel for the respondent number 2 with consent from the other side. Price for listing the matter when?
Any date, lordship.
After a week.
Oh, lordship.
After a week. Here alone.
Oh, lordship.
Is there any interim?
Yes, lordship.
Are you sure?
Item number
11.
11 is admission matter, lordship.
No, is there any interim
I
order?
have not knowledge, lordship.
Okay.
Lordship, I beg to mention item number 27. Kindly take up the matter after a week.
Clearly not received, lordship.
Your name?
As Boshak,
Ms. So-and-so, learned counsel appearing on behalf of
E. Halder.
Mr. B. Halder, learned counsel for the applicant. List the matter.
Interim order passed earlier may be continued.
List the matter after a week.
Okay. Case diary may be called.
On that day, learned additional PP shall produce the case diary before this court. Till then, interim order passed earlier, sir, shall continue.
Lordship, the question listing of matter for tomorrow, Lordship.
Tomorrow not
This for
possible.
today, Lordship, earlier date was fixed for today, Lordship, but not listed, Lordship. This is jail in.
Monday or
14
Tuesday?
months.
Either Monday or Tuesday.
23rd.
May I please, Lordship? Lordship, I beg to mention for listing one criminal appeal with IA, Lordship. Candidate on next week, Lordship.
Okay, you choose the date and take it from
On
court
24th,
master.
24th. Much obliged.
May I please, Your Lordship? Your Lordship, criminal petition 1195 of 2023. It was last listed on 29 December. Kindly be listed on Tuesday
Next week.
next week.
On which date?
23rd.
23rd. Okay.
And Your Lordship, another case, criminal petition 2023 and 2023 both are tag matter. Kindly be listed on Tuesday itself.
Okay.
May I please, Your Lordship, criminal petition number 41 of the 2020. This matter may be listed on 23rd.
23rd. Okay.
Lordship.
Yes.
Lordship, I pray for a listing on Monday, Lordship. It's an IA for a very small jurisdictional issue, my lord. May kindly take it up on Monday because last occasion also.
What matter?
My lord, the person has to leave the jurisdiction. For that, we have filed an IA. It's a long pending.
No,
matter.
no, what matter? Criminal petition,
no.
criminal appeal or revision?
No, my lord, bail application.
Bail application?
Yes,
Okay.
on Monday.
Your Lordship. Lordship, I beg to mention item 36.
30?
36.
36.
CD is there, Lordship.
Why adjournment?
Lordship, the DECA is out of station, yes. So for that reason, Lordship.
Your good name?
A DECA.
Mr. A. Deca, learned counsel appearing on behalf of Mr. B. D. Deca, learned counsel for the applicant. List the matter on when?
29th January, Lordship.
29 January. Okay.
CD is to be retained.
Till then,
Lordship.
CDV retained.
There was an interim order.
Okay, interim order shall continue.
29th. Yeah. Much.
Lordship, I want to beg item number 39.
Yes,
In the next, week. Can be fixed in the next.
next week.
Yes.
Your good name,
And they-
madam?
Is there not received, Lordship?
Case are not received. On the
They are
hearing
interim.
made by Ms. M. Dale, learned counsel for the
Interim may be
applicant.
Continue
List the matter on when?
next week.
Lordship, on 30
30.
January.
Till then, interim order shall continue and the learned additional PP shall produce the case diary before this court on that day. Yes. Next,
I finished for listing a criminal agreement. Lordship.
when?
Last week of this month, 28.
28th.
28.
28 Sunday.
So
On
27 or 25.
Okay.
24.
24. 24.
24.
Holiday, no?
24 January.
Of last month. Lordship.
Lordship, I recommend item number 11, the petition, case number 5948.
Item number 11.
11.
Someone has already mentioned it.
And John, already.
Already mentioned.
You are for petitioner or respondent?
Petition,
Petitioner.
behalf of
Your consent was not taken,
my senior told me mention this.
but the other side told that consent was obtained from you. Probably. Call it. Okay, okay.
May I please, Your Lordship? I beg to mention item 24, Lordship. I have no contact with the client, even I had sent a letter, Lordship. And even the interim order, the petitioner did not come to take even the interim order. So I have intimated him over the phone initially, thereafter I had. sent-
Now, what is your pair?
My prayer, I want to withdraw my Wakalatnama, Lordship. I
Ms.
have
D.
sent a
Ghosh,
letter.
learned counsel for the applicant submits that she has no contract with the applicant and therefore she want to withdraw her Wakalatnama. Pair is accordingly allowed.
Lordship, my postal receipt and the postal receipt where I have sent the letter that also
Submit it to him.
is deeply obliged.
The learned, no, the registry shall issue notice to the applicant. Fixing the matter on Kabir when? 30, okay.
May
Okay.
please, your lordship. Lordship, I beg to mention item number 40, lordship.
40.
Kindly matter may be taken after with lordship. Item number
Your good name?
40, yes. B Gogoi,
Miss B.
Item-
Gogoi, learned counsel appearing on behalf of.
petition lordship.
Your name is not there in the Ukalatnama.
Yes,
Lordship 40 case diary received, Lordship.
You are appearing on behalf of
The UK Burman.
Mr. UK Burman, learned counsel for the applicant. List the matter after a week.
CD to be retained, Lordship.
Lordship, interim may be continued, lordship.
Okay, till an interim order shall continue and CD shall be retained. Okay.
List.
May I plead your lordship? I beg to mention item 22 and 32 of today's brief, your lordship. Case diary is not there, your lordship.
22 and 32.
Yes, your lordship.
CD to be
Your good name?
F. Hussain,
You are appearing on behalf of
SM Abdullah, your lordship.
Miss F. Hussain, learned counsel appearing on behalf of Mr. S.M. Abdullah P, learned counsel for the applicant. List the matter on when?
Any date, your lordship?
1/2/2024.
Interim to continue, your lordship.
In both the matters,
Yes, your lordship.
till then interim order passed the earlier shall continue. Okay.
Oblige, your lordship.
Wait, please, your lordship. Lordship, with respect to item number 45 of daily list, lordship, I am appearing on behalf of opposite party number 2, lordship. Here in this case, I have filed one, if it be in opposition today morning, lordship, that may be bring on record. There is 2 IA. I have filed additional evidence in both the IAs, that may be allowed to bring on record.
Bhavin?
Lordship, I am for the 45 for respondent number 1, Lordship. Lordship, we have strongly objection, Lordship, because Lordship, affidavit call. Lordship.
Yes.
Lordship, I beg to mention item number 21, lordship. Farhad CD not received.
Item number
21.
21 case diary not received, Lordship.
On the pair being made by Mr.
Yes, sir.
S. Alam, learned. MS Alam, learned counsel for the applicant. List the matter after a week. On that day, learned additional PP shall produce the case diary before this court.
To interim may be continued.
Till then, interim order pass earlier shall continue.
Must-
Yes.
May please, but I wish to mention for listing for withdrawal, my lord.
When?
If possible today, my lord,
No,
not tomorrow. one.
tomorrow? Okay, tomorrow.
Another prayer, my lord, for listing a criminal revision petition is a 125 proceeding. And for the wife, my lord, huge amount was pending. The matter was pending.
So what is your pair?
Prayer for listing within
When?
next week.
Next week. Okay.
On 29th. Please, Lordship, pair for listing a criminal petition, Lordship.
When?
Hearing, Lordship, next Tuesday, Lordship.
Tuesday.
Tuesday.
Okay.
Hearing day, Lordship.
How
much cases? On 30. Tuesday, hearing day. But there are too many cases on Tuesday. So on 30. Oblige, sir.
Lordship, I beg to mention for listing criminal appeal, lordship, for
When?
orders.
When?
Next week, lordship.
Next week.
25. Lordship, I beg to mention the criminal petition for listing. Lordship. For listing, Lordship. On 30. On
30,
30 January.
30 January. Huh? That's a need to skip from this.
I beg to mention item number 43 for withdrawal, Lordship. I may be allowed to withdraw this petition.
Withdraw করে লেতে क्या 43 IH से क्या huh?
43. You want to withdraw it
Lordship.
today? Your name?
K. Kashyap, Lordship.
Mr. A. Kaisab, learned counsel. Appearing on behalf of Mr.
I.H. Soikia.
I.A. Soikia, learned counsel for the applicant. This application stands withdrawn. No, stands and dispose of on withdrawal.
Items from daily list. Item 1, promotion bail application.
My lord, in this case, though I am not there, my lord, Mr. P. Chutia, his father is admitted in hospital, so he asked me just to say that case diary may be called for.
Your Ukalatnama is not there.
My name is, telephonically, he called me to, his father is admitted in hospital, so I'm appearing on his behalf.
Heard Mr. M. Biswas, learned counsel appearing on behalf of Mr. T. Sotia, learned counsel for the accused. This application under section 439 services referred by accused Idris Ali and Zakir Hussain, who are languishing in jail Hazrat in connection with Bosista PS case number 842 of 2023 under section 379, 411, 34 IPC. Read with section 13(1) of the Assam Cattle Preservation Act. Read with section 11(1)(d) of Prevention of Cruelty to Animal Act. Since 1/1/2023 for grant of bail. Having heard the submission of learned counsel for both the parties, perusal of the case diary is found to be necessary, and accordingly it is provided that case diary be called for fixing the matter on
29.
29.
29.
Item number 2,
Please, Your Lordship. Total 57 days custody, Your Lordship. Foxo is there.
Total?
57 days.
57 days.
Foxo is there, Your Lordship.
Also is there. And notice has to go.
This is number 11, Your Lordship.
And 376 AB is there. Is it?
Four and
maintainable?
12 of Foxo notice will be given.
No, madam, on 376 AB is there.
It is 76 AB.
So as per section 438 subsection 4.
No, 439. Custody, 57 days.
Acha, okay. Well, let notice be issued to the respondent number 2 by registered post and also by usual process, and also through the officer in charge jurisdictional PS, fixing the matter on returnable on when.
For a shorted, Your Lordship, 57 days already in custody, Your Lordship.
Lordship on 30.
30 short date. First week of February.
First week of February.
So on 30 May, can Your Lordship, on 30 January, Your Lordship.
On 5th February.
No notice has to be served.
On first or second, Your Lordship.
On 5th.
Second, okay, second.
Second February.
Second. And
Bless you.
the learned additional PP shall produce the case diary along with the statement of the victim girl recorded under section 164 CRPC and the medical report of the victim on that day.
Bless you.
Item number 3,
May I please, Lordship? For 39 application, Lordship. FIR is case 7, Lordship. It was under section
When
499,
he was arrested, 9/1.
9 on Lordship. No money has been recovered from the accused person, Lordship.
Pardon?
No money has been recovered from the accused person, Lordship.
But there was attempt. Let the city come, madam.
Lordship.
When?
Lordship, Bhangaghar PS, Lordship, can you sort the name? Bhangaghar.
Lordship, 2nd of February.
Sort that.
29.
29. Okay.
Item number 54,
please, your lordship.
Yes.
So 439 bail application, lordship, under section 406 and 420 IPC, lordship, and already with 53 days behind the bar, lordship.
53.
Lordship, page number, FI is page number 10, lordship. Kindly come to page number 10, lordship. May I read, lordship?
Yes.
Lordship, more respectfully, it is submitted that I am by profession an assistant of a contractor. Due to the contract business, I am into contract with said accused person. The accused person introduced himself as a contractor to me. Subsequently, a friendly relation cropped up between us. In the month of January 2023, the accused informed me that he was granted a contract work for construction of office building of Assam Rifles located in Dhilai Gate, Chandi Market, Karbi Anglong district, and gave me a proposal to become his partner in execution of the said work. Furthermore, he has also told me that told me to supply laborers for the said work, lordship. Believing the accused in the month of January of this year, I gave him rupees 1 lakh, and by the said money, he started the construction work of the building. And that for the work, I had also provided 50 laborers. But it is stated that the said work continued for 3-4 months, and while the construction work was going on, for the execution of the said work, I borrowed of rupees total 11 lakhs from a person by mortgaging my land, by giving checks, as well as by signing in a blank stamp paper and handed over the said amount to the accused person. About rupees 12 lakhs 43,000 remaining as outstanding payable by me to the laborers as wages and other expenses. About 4 months back, the accused obtained a bill against the contract work. Thereafter, I asked the accused to return back the money I had given to him and pay the wages to the laborer. But the accused has been delaying the payments on the pretext or other. About 2 months back, when I asked the accused to return my money, the accused told me that he will not return the money and also threatened me of dire consequences if I again ask for the money. After this, the accused does not receive my phone call. Due to such activities of the accused, I have definite that the accused has misappropriated of my money and as well as wages of the laborer. Be it stated that the transaction of the said money was done in my house situated at Sonari, Bali. But lordship, this is a totally civil in nature, lordship. If the petitioner has borrowed the money also, lordship, this informant can file a money suit, lordship, if presumed that this petitioner has borrowed the money. Filing an FIR and dragging the petitioner in criminal cases, lordship. This is T3 days behind the bar, lordship, and statutory period will be 60 days, lordship. So there's the punishment in 3 years and 7 years, lordship.
Pardon?
Lordship, already 53 days in behind the bar, lordship, and statutory period will be 60 days, lordship. Should we grant the bail, lordship?
Yes, madam.
Lordship, short date CD will be there.
But whether you will be able to produce the CD? It is from Karbi Anglong or from which place? Samaguri, Nagaon. Okay, on Monday,
Monday, 20.
produce the case in CD on Monday.
Item 55.
Eight is a lordship, a 439 bail application, FIR is at page 9. Can I go through it, lordship?
Yes.
Sir, with due honor and respect, I like to state that on 2/1/2024 at around 5:24 AM, a money transfer from my account number so and so has taken place without my knowledge. At that time, only my helper was present in my house along with me. So I suspect him to be involved in the matter. This is for your information and necessary action. Lordship, thereafter the petitioner was arrested, lordship, who was the helper of the complainant, Dr. Dilip Kumar Sharma, lordship. Kindly peruse forwarding report at page 16, your lordship. page 16 annexure B, Lordship. A ground of arrest at the last point F, Lordship, the article involved in the has been recovered, Lordship. So there are article has also been recovered, Lordship. Scissor also has been annexed, Lordship. 14 days already behind the bar, custodial interrogation cannot be required, Lordship. A 19-year-old boy, Lordship. Their name and address of the accused person is also there in the forwarding report, Lordship. And Scissor list is at annexure C, Lordship. Both the mobiles have been recovered, Lordship.
No, there was money transfer from his account.
Lordship. The complainant, the petitioner was working with him, Lordship.
Pardon?
The petitioner was working at his house, Lordship. He was the helper of the complainant, Lordship.
No, whether the money was recovered.
Lordship, here the article involved in the has been recovered, Lordship. Here it is forwarding report, it has been reflected, Lord.
Where?
At annexure P, page 16, Lordship. Round of arrest F, Lordship.
Yes. No, whether the amount has been recovered.
That is not there, Lordship.
That
Only
is
the one
the
article.
article.
So then let the CD be there, Lordship.
19-year-old boy, Lordship, already 14 days, Lordship.
14 days, Lordship.
So, forwarding report reveals that 82,999 rupees transferred from his
Lordship.
bank
Not
account.
the account.
Whether that amount was recovered or not.
That is
That
not
was
there.
that is not properly reflected, but the article here involved in the has been recovered here, reflected, Lordship.
So the Caesar list is also silent in this video.
Yes, Lordship. That is also
Let the CD come. CD on, madam, when?
CD on
dispute, Lordship. Next. Dispute.
Lordship 25,
25.
25-1.
Okay.
Item number
Oblige, your Lordship.
5.
May I please, Your Lordship?
Yes.
Well, this is a application for the quashing.
This, what is this 166?
166, my lord, in discharge of the official duty. The cognizance has been taken, my lord,
Under that section.
under that section.
It is
Police
a
officer, my lord,
bailable offense or non-bailable offense?
it's a, my lord, bailable offense.
What is
Otherwise,
the punishment?
punishment, my lord? One year,
1 year.
simple imprisonment. For 1 year, my lord. Public servant disobeying law, my lord. Well, that's the. So, my lord, what happened initially, my lord? FIR had been initiated by me, my lord, on 29/9/18 against the respondent, basically, for carrying illegal, my lord, petrol. And I have detained the
Carrying illegal
petrol, my lord.
petrol.
Diesel tanker, my lord.
Hmm.
On the basis of an GD entry, the information is given by the oil itself. Then accordingly, I have detained on 29/9/18. Detained the thereafter FIR has been initiated by the oil. In the meantime, the owner of the petrol tanker, my lord, he has filed an FIR, my lord. That for illegal detention, my lord, page 35, my lord. Page 35, Lord. This is the FIR filed by the counter FIR filed by the respondent number 2, my lord. Page 37 is the part, my lord. Subject FIR. Due respect that I beg to state that the Indian Oil Limited has authorized MS so and so to carry GSC so tanker from Digboy to loading point is a different question of the on French line. About 10:30 about an oil tanker bearing registration number so was loaded in the Digboy for unloading the same at the so place. After loading the high-speed diesel, the point of the chamber tanker has been duly locked and keeping one key in the custody of the IOCL authority and other key in the custody of the unauthorized person unloading point where it is the oil is supposed to be unloaded. The driver of the vehicle proceeded from Digboy to the Nandua and on the way parked the vehicle at the authorized parking point situated at the Lahori Kochari village, Tinsukia for refreshment and taking food. Thereafter, he proceeded to his destination and they waved out so four per person wearing police dress boarded the Tata Sumo, wrongfully restrained the vehicle on the disguise of the verification and told the driver of that the high speed oil has been mixed with the foreign articles, and which the driver told that the filling points has been duly locked and such as the allegations are not rational. Thereafter, the said person demanded driver of the making payment of 50,000 and warned that the failure to concede the demand and will get the vehicle seized through the police. Then the driver refused to accept the illegal demand and they called the Tinsukia police, and accordingly Tinsukia police reached to the place and took the vehicle at about 2 Tinsukia police station No FIR lodged at the police station, but the vehicle is kept confined in the Tinsukia police station and the driver Sharma, handyman have been detained in the police station. So this is the basic fact.
Where is the
Then,
this
my
the
lord-
impugn order?
Well, thereafter, Lord, you kindly see, they have filed one petition against me, my lord. Page 42. Page 42. This is the petition filed by the respondents once again that officer in charge Tinsukia police station that I have illegally kept the vehicle without informing the court. Next page, my lord, 43, Lordship will find paragraph 4. 44, page 44, paragraph 4. The petitioner on so at amount visited the police station, made inquiry regarding the detention of the vehicle, but no answer has been given by him. The available police person on inquiry on the court, no cease report has been in respect of the aforesaid vehicle. The vehicle has been detained on the police station on so date to so period without affecting seizure and the report to the honorable court. Thereafter, the amounts to disabling the law and the offence under the Indian Penal Code. So this is the complaint filed by them. Now, Lordship kindly see page 55. So accordingly, show cause was issued to me by the CGM on the basis of their complaint, and I have been exonerated on this matter by the court itself. Page 55 starts, my lord. The
So this is the impugn order.
no, not this is the impugn order, my lord. Page 56, I have been discharged by the.
No, impugn order dated 5/8/2023.
No, this is 8/10/18, my lord. This is Chief Judicial Magician initially on the basis of their complaint, my lord.
Hmm.
Issued show cause to me. I have replied on the basis of that show cause, and it has been accepted by and accordingly, my lord, this is the order passed on 8/10/18 by the CGM. Lordship, can you see page 56, the third paragraph? The written show cause reply submitted by CSI Pratap Gogoi is accepted considering the mistake made is bona fide with direction to be cautioned in future. So I have been expunged because their complaint is that unauthorizedly I have kept the vehicle in the police station because I have to report it forthwith. So as I didn't do it, so accordingly, my lord, this is the complaint they have initiated. Then thereafter, the same complaint again made by complainant on page 73 now, on the same allegation.
Page
73, same allegation. Same informant, same allegation, page 73. I am on that, my lord. Page 73. The main allegation, Lordship will find page 76, paragraph 12. So I have been made as an accused number 3 in this complaint, my lord. That the accused number 2 and 3 detained the vehicle loaded with the so-and-so liters high-speed oil in police station without any valid authority, and so-called investigation is carried out against the mandate of the law, that too without the informing to the magistrate as necessary under the accused number 2, 3 on the behest of the accused number 1 did the aforesaid illegal acts which amounts to the offence under as the law so liable to be prosecuted under section 166, 286, public 34 in Indian Penal Code. Now cognizance has been accordingly taken. Page 88, madam. Page 88. Page 89, last paragraph. However, I find sufficient incriminating materials against accused Gopal Chandra Bora, accused Pratap Gogoi, to proceed against them under section 166, public 34. Hence, the cognizance is taken accused the Gopal Bora and the Pratap Gogoi under 166, public 34. Madam. They have not challenged that CGM order, my lord, initially by which I have been exonerated. That was neither mentioned in the complaint petition. They are totally silent about it. Filed this complaint on the same facts.
So the order by which you have been exonerated by the CJM is 8/10/2018.
Yes, my lord.
It is page number 55.
Yes, yes. And without this.
And where is the complaint which led to passing of this order?
That is, my lord, page 73 onwards, my lord.
No. This order was passed.
Yes. my lord.
8/10/2018.
Oh, that is, my lord. That petition lordship will find at page 42. 1/10/18.
42.
42. Paragraph 4 is the main allegation, my lord.
So what is your prayer in this petition?
My lord, for the quashing of the complaint as well as by the cognizance order, and this is the order without the sanction, my lord. Because the allegation is the direct bearing with discharge of my official duty. The whole allegation is such that in discharge of my official duty, I have not informed the courts regarding the seizure of the vehicle, which has been subsequently, I have been exonerated by the court. They have filed the second complaint on the basis of which the cognizance has been taken. In the complaint, they are absolutely silent regarding the initial exonerated by by which the court has exonerated me. They have suppressed that fact in the complaint. Absolutely vexatious complaint, my lord, with a malafide intention. And lordship knows the sanction is very much necessary in this kind of cases. The sanction is not there.
No, the question is whether the second complaint is maintainable or not.
Yes, when the mine first was I was rejected, the court has accepted the first complaint. I have been exonerated by the court. Then suppressing that fact, my lord, they have filed the second complaint on the same facts. Not even a whisper that I have been exonerated by the same court on their petition itself.
Okay, we will pass the order, but in the meantime, let the additional PP go through this both the complaint, whether there is the facts are same in both the.
Facts are same, my lord, exactly my lord, same, my lord.
Lordship,
Let
there is
her
a
go through the
order
record.
Page number 94, Lordship. Page number 94.
Yes. My lord, initially what happened, my lord, that part, we have challenged that part, the taking of cognizance before this High Court. High Court has returned the case to file it before the session judge. With a liberty.
Yes.
Right. Page 26, Lordship will find, sorry, my lord, page 92, annexure 26, my lord. Page 93.
And thereafter, what happened?
Then we have revision filed. We have filed a revision before the Sessions Court. And the Sessions Court has dismissed it that there is a delay and the sanction is not, and we have not taken any liberty from the High Court to file it. That is the ground.
No, liberty here, that para number 3 of the page
Yes,
number
yes.
93.
Yes, yes. That Lordship will find, he is finding the last paragraph, page 111, my lord. The last paragraph, by which the session judge has rejected our petition. Page 25, 111, my lord. The learned counsel for the petitioner submitted that the petitioner was serving sub-inspector at police at so-and-so at 11 as such entitled to protection under 197 of Criminal Procedure Code. On perusal of the order passed by the criminal petition number 667, the Honorable High Court, that no such ground has been taken at the time of seeking liberty for withdrawal of the said petition before the Honorable High Court. Yes. So ground was not entertained. When we take liberty, my lord, we don't take liberty for a particular section wise, my lord. That I have to take the liberty for filing the case on this particular section, my lord.
Is it necessary?
Not necessary, that's what, my lord. And when we take the liberty, you have withdrawn the case because of the High Court order. High Court has given direction to approach the revisional court first. So accordingly, liberty has been taken and we have filed it. But the learned Sessions Court, he is under the view that you have not taken the liberty to approach the court under 197.
So this order has not been challenged.
You have challenged it. This order also I have challenged.
Yes.
Yes. Both the orders we have challenged.
Okay, we'll pass the order. In the meantime, let her go to the record. Madam, these
Cases
page
are
numbers
pending
are
for
marked
not
here.
appearing, Lordship. Here, accused Pratap Gogoi is absent since the petition. All this year he was absent, Lordship. For him only the case is pending, Lordship.
No, I am not concerned with that. I am concerned with whether the facts mentioned in both the complaints are
Lordship, that is
same or
clear,
not.
Lordship. That-
Okay, we'll pass the order.
Problem.
Madam, you go through the record and let me know later on.
Lordship.
Item number 6.
My lord, the next date is on Monday, my lord.
Pardon?
Next date is on Monday, my lord.
No, we'll pass the order today.
Problem.
May please.
Yes.
Yeah, Lordship, FIR is at page 12, Lordship. Allegation is that the informant is the owner of a plot of land. And on 15/11/2023, some person trespassed into their land
And when they going through the record, they came to that 4 numbers of sale deed has been executed by the petitioner on the
No, on the last day, we have
Yes.
asked the counsel for the petitioner to produce the
Yes.
power of attorney.
Yes.
Yes.
This is a registered one also.
So the allegation was that this power of attorney was false.
False. And prior to lodging of this affair, they have filed a suit praying for declaration of their right title interest, cancellation of this power of attorney, and the subsequent sale deed. In the FIR, there is no whisper that there is an agreement in between the petitioner and the informant. We have annexed the plain lordship. There they have admitted that there is an agreement and received the 50% of the amount lordship. That is at page 27 lordship, annexure 3. Page 30 is that about the agreement.
Page
Page 30 lordship. Paragraph number 2 of the plain lordship. 3G.
Yes, madam.
Lordship, let this CD be there, Lordship. Case diary will be required, Lordship.
In the meantime, interim may be given Lordship, he will appear
Yeah,
Lordship,
yes,
record
very
statement Lordship.
Case diary after case diary, Lordship.
It is an admitted position Lordship, there is an agreement, they have received the 50%.
But this signature in the
Power of it.
power of attorney and signature in the FIR are different.
That is a matter of trial Lordship,
Maybe.
because admitted position is that
But,
there is an agreement Lordship.
Pardon?
There is an agreement in between the parties and the informant has received 31 lakhs 10,950. They have admitted in their claim. The dispute arises because that after the payment is made by the informant, by the petitioner, they have executed the power of attorney. On the basis of that power of attorney, he has executed forcefully. And when the petitioner approached them to receive the balance consideration money, they refused because the petitioner sold the land at higher price. That is the reason behind this suit and the FIR.
Pardon?
Because after making payment 50% of the amount,
Mm.
the power of attorney was executed by the informant themselves. On the basis of that power of attorney, the petitioner executed forcefully to purchaser in respect of 50% of the land.
But the power of attorney in this signature is appear to
Signature
be
about the
dissimilar.
That is a matter of trial Lordship.
No, that's
That-
all right. But
But that is a registered one Lordship. That has to be.
maybe. How it was executed? This power of attorney on commission?
It's maybe on commission Lordship. Photograph is there Lordship.
No, mere presence of photograph will not justify the signature.
Photograph and the seal of the sub-register office is there in last page Lordship.
No, if when it is registered, invariably there will be the
Yes.
Seal and-
seal.
Here Lordship,
But my question is whether it was executed on commission.
maybe on commission Lordship, because there is.
Let the city come. City on Madam when.
Lordship,
The interim may be considered Lordship, and he will appear and produce the original Lordship before the IO.
When?
here,
On 30,
30.
30.
City on 30. No interim period. This is.
Carry number 7.
For 38 petition matter. Petition is not a named accused in the FIR matter. The FIR is page 9 matter. Only allegation of the stolen property recovered from the neighbor house of the petitioner. My lord, the one Shibo Rajbongso was arrested with some iron rod, and other some one my lord Otul, Konkon, Totan, Fokan were with him, and thereafter the stolen property was handed over to Shibo, my lord. But petitioner is not named accused, and also he is not involved in this case. But his police was visited to the house of the petitioner. That is why on apprehension filed this incident. And it is bail matter for paying for indigent bail.
When this Shibu Rajwangshi was arrested,
Shibu in the my lord, on the on red-handed method he was
15-12, Lordship.
I am for Danish Ali.
where is the forwarding report of this person?
That was not.
So why you were apprehending arrest?
And that stolen property was recovered from the neighbor house of the petitioner, and
From the
also neighbor house of the petitioner.
neighbor's
And
house of
on
the petitioner.
And the police also visited to the house of the petitioner. That is why on apprehension matter. And this is the
So your house is also visited by police.
man.
Yes, madam.
Lordship, as you have not annexed the forwarding also, Lordship. So, Lordship, let the CD be there, Lordship. At this moment, Lordship, nothing we cannot say with it. Because his name is not there, Lordship.
His name is not there.
His name is not there. Then why his apprehension is there, Lordship? Is there forwarding also is also not there, that some other person, that is also not mentioned, Lordship.
Okay, let us see the produce. So in the meantime, we'll grant interim protection to him. Heard me, sir?
Yes.
The Islam Learned Council for the applicant, and also heard Mr. Miss A. Begum, Learned Additional PP for the state respondent. Apprehending arrest in connection with GRPS case number
257.
257 of 2023 under section 379 34 IPC. This application under section 438 services preferred by applicant Danesh Ali. For grant of respect. It is to be noted here that above noted cases been registered on the basis of an FIR lodged by one Sujit Kumar Singh on 15/12/2023. The essence of allegation made in the FIR dated so and so is that on 15/12/2023, the informant had apprehended one Shiba Rajbangshi with one e-rickshaw and with some stolen iron articles. And on being asked, he disclosed that one Atul, Konkon Das Toton, and Kokon Das of Maligaon are also involved in stealing goods, stealing iron articles from New Kamakhya railway station. From New Kamakhya railway station. Mr. Islam Learned Counsel for the applicant submits that the name of the applicant is not there in the FIR and he is no way involved with the offense list, but he is being searched by police. And also some of the neighbors of his house are also being searched by police, and therefore he approached this court by filing the present application. And that he is ready to cooperate with the investigating agency, and therefore it is contented to allow this petition. On the other hand, Ms. A. Begum, Learned Additional PP, submits that his name is not there in the FIR, but perusal of the case diary is necessary as to ascertain as to why he is being searched by police. Having heard the submission of learned advocates of outside, perusal of the case diary is found to be necessary, and accordingly it is provided that the case diary be called for fixing the matter on when
9/2, Lordship.
9/2.
9/2.
Having considered the submission of learned advocates of both sides and also considering the nature of accusation and the punishment prescribed for the same, this court is inclined to extend interim protection to the applicant till receipt of the case diary, and accordingly it is provided that in the event of arrest of the applicant in connection with case number so and so, it shall be enlarged on interim period as well on his executing a bond of rupees 50,000 with one security of life amount to the satisfaction of the arresting authority. The above privilege is, however, subject to the following three conditions. Last condition, he shall not leave the jurisdiction of CJM, Kamrup M, without prior permission.
Item number 8.
Arresting authority GRP.
Pardon?
Arresting authority GRP Kamrup. Kamakya.
Pardon?
GRP. Arresting authority is the GRP, OP, KYO, TV. What?
May it please your lordship. My lord, this is a pre-arrest bail application of a lady who is aged about 64 years, my lord. Apprehending arrest in connection with an FIR of Bholumukh PS case. My lord, she approached this honorable court. That FIR your lordship will find at page 85. And the relevant portion type copy starts at, my lord, page 89. Well, so far page 89 to 91 is concerned. Well, this FIR is directed against Sri Pradip Kumar Das. Well, at page 89, the last paragraph, his name is mentioned. So far this FIR was concerned, my lord, my name is not mentioned. So who I am? Well, I am the purchaser of a land who has purchased this land from Pradip Das by executing a sale deed. I have annexed a copy of the sale deed, and through bank transfer, I have transferred 1 crore 60 lakhs in the name of Sri Pradip Das. Malad, in connection with this case at page 89, Pradip Das approached this honorable court and he was also granted pre-arrest bail. Malad, prima facie, since from 89 to 91, my name did not appear in the FIR, my lord. And since there is a civil suit already pending, there is a criminal case also pending in same set of allegation. Mutation has been granted in my favor. Your lordship granted me pre-arrest bail that your lordship will find at page 102.
No, is it the same case number?
No, my lord, just let me give. Now I'm coming to the second. In case of page 102, your lordship will find your lordship's order. Your lordship has granted bail to me in connection with Bholumukh PS case number. So, my lord, in terms of your lordship's order at page 102, my lord, the IO asked me to come to the police station for interrogation, my lord. On that particular day, I was not well. I sent my son giving my medical documents and my reply to the notice under section 41 that I'll appear on the next day. My lord, without any rhyme or reason, my son's name does not figure in any of the list. In any of the where in the FIR, sale did nothing. He has been arrested and forwarded to the court of the learned Chief Judicial Magistrate Kamrup Metro at Guwahati. My lord, the magistrate who was presiding on that day, my lord, on perusal of the documents, on day one granted bail to my son. Now my apprehension is, my lord, so far Bholumukh PS case, your lordship has protected me. Now there is a general FIR, my lord. Your lordship will find this is under the general FIR which I'm approaching, my lord. So what has happened? Pradip Das, who was earlier granted bail in case of Bholumukh PS case, the IO finds that he has been granted bail in Bholumukh. He has now been arrested in the case of a general FIR. In that case also, this court has granted the bail. That general FIR, your lordship will find page 119. I am now against the general FIR because my apprehension is now that if I go and appear before the police, they will arrest me in case of the general FIR at page 119. And the relevant portion your lordship will find at page 121. This is a FIR of 28th of September 2021, page 121. Probably your lordship has occasion to go through this FIR, my lord. It is an omnibus FIR with omnibus allegations. And in this FIR, as many as 95 persons have been named, which includes offenders, land brokers, miscreants involved in Kamrup district. This list is at page 124. In this list, my lord, my name does not figure. And in connection with this case, my lord, many persons were arrested, my lord. All of them have been granted bail, some of pre-arrest bail, some on regular bail. And I have been able to collect as many as 15 orders, which I have annexed from page 127 to 156. From page 127 to 162, I have annexed the orders of the bail granted to different person in this case, my lord. And I have made a compilation on the ground on which which this honorable court has granted bail. So my now apprehension is, my lord, since your lordship has protected me in the first case, on the basis of this omnibus FIR, where this honorable court has granted bail to almost all the accused, I could collect 15 orders. And since Pradeep Das has been arrested in this omnibus FIR and granted bail by this honorable court, that's why your lordship will kindly protect me in this second case, and I will go and appear before the IO immediately as your lordship directed. In the first case, your lordship being a woman, and since there was no specific allegation in the Bhordlumukh PS, your lordship did not direct me to go and appear. But when they summoned, on that particular day, I was not well. I sent my son. My son was arrested, and he was also granted bail by the trial court on day one itself. And Pradeep Das has also been granted bail in this case, my lord, in this omnibus FIR, who was a name accused in the first FIR where I have been granted bail, my lord. And when there is a specific FIR with specific allegation, when there is a protection from this honorable court, my lord, I am willing to cooperate. But now, because of this omnibus FIRs, my lord, when people get bail in one case, they just sit as an appellate authority above the orders of the court and arrest them in that general FIR. And in the general FIR,
Okay.
yes.
Yes, madam.
Lordship, let the CD be there, Lordship. Let the CD be there, Lordship. Short date, Lordship.
But there is no specific allegation in this FIR dated. FIR is dated 28/9/2021.
That is Lordship, but earlier also one case is there where Lordship have granted bail, Lordship. That CD is fixed on 11/1/2024 this month, Lord.
No, it was on that day, did not raise, the court extend the interim, and it is fixed on 24th, or in the first week of February. Now, so far this FIR is concerned, my lord, no specific allegation. All persons who have approached in case of this FIR have been granted anticipated bail or regular bail, madam. That's why, and since your lordship has protected, I have not violated the conditions of this bail. So I will cooperate with the investigation, but only thing is that when I will be kept under detention, my lord. My son went to give my order of this court in Bhordlumukh, he has been detained. And my son's bail order, your lordship will see, on day one, my lord, all sorts of allegations made against my son. But even then, the London magistrate granted me bail, my lord.
Heard Mr. B.D. Kumar, learned counsel for the applicant, and also heard Ms. A. Begum, learned additional copy for the state respondent. Apprehending arrest in connection with Crime Branch PS case number 11 of 2021 under section 120B, 420, 409, 467, 468, 471 IPC. This application under section 438 CRPC is preferred by Srimati Sarita Devi Jain for grant of periodic bail. The above noted case has been registered on the basis of one FIR lodged by ADC Monindra Bordoloi of Kamrup Metropolitan District on 28 September 2021. The essence of allegation made in the FIR dated so and so is that his office received regular complaints in respect of the corrupt officials of several circle offices of Kamrup Metropolitan District who used to engage undesirable middlemen to collect the undue advantage, significant bribes, and also adopted corrupt practices such as hampering the delivery system of revenue administration and causing severe inconvenience to general public. And specific incidents came to light through sources information and also in newspaper reports in Yamiya Bhatta. wherein it has been reported that in Nunmati, Narangi, Gopalnagar, Salbari, Kailasnagar, under Guwahati Circle, the middlemen have been collecting 50 to 1,000 rupees from the landless people in the name of issuing land patta. And irregularities have been reported from different revenue circle offices of the district. Which indicate large scale nexus and deep rooted conspiracy amongst the middlemen as well as public servants. A list of 95
Yes, ma'am.
suspected offenders, stroke land brokers, stroke miscreants involved in the Kamrup district also enclosed with the aforesaid complaint. Mr. B.D. Kaur, learned counsel for the senior counsel, assisted by Mr. So-and-so, submits that the name of the applicant find no mention in the list, and the allegation made in the aforesaid FIR are omnibus in nature, and that the applicant had purchased a plot of land from one Pradeep Kumar Das, and she got the aforesaid plot of land mutated in her name, and thereafter a case has been filed being Bharlamuk PS case number. What is the number?
357 of 2023.
57 of 2023. And in the said case, the applicant has already been granted the privilege of previous bail by this court, and that the applicant is ready to cooperate with the investigating agency. And in the aforesaid cases, the applicant was directed to appear before the IO as and when directed, but she could not appear before the IO, and she has sent her son, wherein her son has been arrested, and he has been granted bail by the learned chief judicial magistrate on the same day, and that the applicant is ready to join the investigation, and therefore it is contented to allow this petition. On the other hand, the learned additional PP submits that perusal of the case is necessary, and therefore she has prayed for calling the case diary. Having heard the submission of learned advocates of both sides, perusal of the case diary is found to be necessary. And
Objection may be recorded.
accordingly, it is provided that case diary be called for fixing the matter on
Same day on the
9th
February.
9th of February. It also appears from the case diary, from the record, that the name of the applicant find no mention in the FIR dated.
FIR dated, my lord. FIR dated 20th of September 2021. Page 190.
And having considered the nature of accusation and the punishment prescribed for the same, and also the materials, also the nature of allegation made in the FIR dated so and so, this court is inclined to extend interim protection to the applicant till receipt of the case. And accordingly, it is provided that in the event of arrest of the applicant in connection with crime branch PS case number 11 of 2021 under section so and so, she shall be enlarged on interim years bail on her executing a bond of rupees 50,000 with one security of like amount to the satisfaction of the arresting authority. The above privilege is over, subject to the following three conditions. Last condition, she shall not leave the jurisdiction of Kamrup M without prior permission.
If you,
Shall appear Lordship whenever she was needed Lordship.
yes, yes.
She will appear Lordship this time.
Item number 9, matters for admission.
Yes, Your Lordship. My lord, this is an application under section 482 ARPC, my lord, for quashing of the impugned FIR dated 21/2/2017, charge sheet dated 29/6/2022, as well as the criminal proceeding, my lord. Your Lordship may kindly see the FIR at page 14, my lord. The petitioner before your Lordship is accused number 3, my lord, page 14, my lord.
Whether the record was called for,
No, my lord.
not called for.
Notice was issued Lordship.
Your Lordship may call for the records.
Service completed.
Okay, heard Mrs. S.B. Chaudhary, learned counsel for the petitioner. And also heard Ms. A. Begum, learned additional PP for the state respondent. It appears that service in respect of respondent number 2, 3, and 4 has already been completed, but none appears for the respondent number no, but the respondent number 2, 3, and 4 remain unrepresented today. So where the matter is pending now?
My lord, it is Hailakandi, my lord, for the court of the learned chief judicial magistrate.
CJN?
Chief judicial, yes, my lord, CJ. Then appearance date, my.
Madam, is it necessary to appoint someone as amicus curiae, no, as legal aid counsel to represent the respondent number 2, 3, and 4?
Lordship, it is better to appoint Lordship because they are not appearing Lordship after complete of the service also. They have not appeared till date Lordship.
Since the respondent number 2, 3, and 4 remain unrepresented today, this court is inclined to appoint. Huh? Legal aid counsel. Regular. He is only regular. Madam, whether the Dipanjali Borpuzari Deka is regular in court?
It's very clear for me. They are present that everything now. I have.
Yes, we do assent, huh?
Lordship, she is presenting the name of S. Kanangu. He is there in amicus curiae.
No.
Her name is not in the list.
Her name nine.
In any area, Dipanjali Borpuzari Deka.
She is there, Lordship. She is there.
List of 9.
She can appear. She is regular.
Amicus curiae. Amicus curiae को जो पढ़े. A Begum है.
P. Begum. Tasneem.
Your name is not here. Legal entity. Criminal matter is
The previous list, her name is reflected in the previous list.
But recent list, her name is not there. 6 December 2020. Dipanjali Barpuzari Deka.
Left check.
And in the meantime, registry shall call for the scanned copy of the record and the case diary from the Court of Learned Chief Judicial Magistrate, Hailakandi. Hailakandi. And list the matter after 1 month, 4 weeks,
4 weeks.
4 weeks.
Matter number 10.
My lord, in this case, there is no interim, my lord.
Pardon?
Still, my lord.
Let the record come.
Did the record.
Let the record.
A report was called for, are there?
Scan copy was called for.
Scan copy of the LCR.
It was there on the last page.
LCR is there. Also report on it.
Hmm.
So this is the matter pertaining to the Jimma of a commercial vehicle, Your Worship.
Yeah.
The last occasion,
Scan copy.
scan copy was called for. And it was a certificate matter, Your Worship. And the Jimma, the commercial vehicle is lying up from the last 9 months in the custody of the police station. Your Worship.
It was seized in connection with NDPS case.
APS 21B, Your Worship. The petitioner here is the registered owner of the vehicle, whereas the accused person was the driver during that time who kept in the car without the knowledge of
The question is whether seized the vehicle in connection with NDPS case can be released.
Lordship, section 60, there is an exception to it, Your Lordship, when there is no knowledge of the owner, Your Lordship.
What are exceptions?
The section 60 of the NDPS Act, Your Lordship.
Section 60.
Point 3, Your Lordship. Unless the owner of the conveyance proves that it was used without the knowledge of the owner himself.
So subsection
3. Moreover,
whether his knowledge was there or not, that can be ascertained only at the end of trial.
Lordship, but this
At this stage, how can we ascertain that his knowledge was there or not?
the case has been registered upon the driver of the vehicle, Your Lordship. And he has been certified in this case. The owner has nothing to do with it. He has not.
Owner has not been certified.
Not been certified, Your Lordship. He is not the accused person in this case. Moreover, Lordship, in the recent case of the Guwahati High Court passed by the Honorable Justice Malashi Nandi, a detailed order was passed where judgment was passed where the case of Sundarlal Desai case is applicable in NDPS also, Your Lordship. I have the same with me, Your Lordship. It has been clearly mentioned.
No, Sundarlal Desai was mainly in respect of the offenses under IPC. Hmm?
Point number 33 of the detailed judgment, Your Lordship, here, it has been clearly stated that on the basis of the above discussion, this court is of the view that the law laid down by the apex court in the Sundarbai Ambarlal Desai will apply to the page 19 slash 19 vehicles seized under the NDPS Act as well. Moreover, the accused person is also on bail, your worship. The registered owner is suffering for the last 9 months. This is his livelihood.
Yes, madam.
Lordship, earlier in this petition, there is somebody written that a report was called for, Lordship, whether the vehicle is required or not. That I'll confirm, Lordship.
No, what report is necessary? It is a sensitive case.
No.
The
Jimma-
Sergeant matter, it is something, PW. This stage of PW,
For Jimma of the vehicle.
it has already been 5 days of one month.
That is, I have seen search it. Vikas to the heavy Vikas police custody as it. That is the thing, no? That vehicle is lying in the police custody, Lordship. So whether
Mr. Kyle. Oh, the other day in connection with granting Zimma of one seized vehicle
Yes, sir.
in NCB cases, you have referred to one case law of Supreme Court.
Yes, sir.
Do you have the number?
I think probably I may be a copy of that. I'm just finding out.
Okay, we reject the order. Heard Mr. S. Ahmed, learned counsel for the petitioner. And also heard Ms. A. Begum, learned additional PP for the state respondent. Argument concluded, judgment reserved.
Alright.
Item number 13.
None appears for the accused on call, leaves the matter after 1 week.
Item 15. Item number 15.
Losses, item 13 loss. Item 13.
We'll take it as the last item, not now.
Item 15.
15.
Item 13 is last question. So item number 15. 15 council.
Yes.
I'm sorry.
My lord, this man is in custody for 3 years, 3 months, and 17 days. 3 years, 3 months, and 17 days. That is 1,204 days. Total number of witnesses are 8, my lord.
How many
Only-
witnesses have been examined till
Only
date?
3 has been examined till date. Charges were framed on 16/11/2021.
Hmm.
Now, my lord, no contraband was recovered from the possession of the petitioner. The petitioner is arrested based on a statement of a co-accused under section 67 of the NDPS Act. The petitioner was never absconding. He received a notice at his residence. He had voluntarily come to Guwahati. He had voluntarily come to Guwahati in the NCP office.
Why?
A notice was issued because he was the owner of the truck as per the
No,
NCP.
you have already submitted that he has not received any notice.
No. I said on receipt of notice, he has voluntarily come. It is not that he was arrested by the NCP. I will show all this from the records. I'm just, my lord, I'm making the broad grounds of my submissions, my lord. Then, my lord, the 3 things based on which I was arrested are: number 1, that I am the owner of the truck; number 2, that under 67 of the NDPS Act, I am implicated by a co-accused; and number 3 is the call record of a phone number which is admittedly not registered in my name. Now, I'll show from the records, my lord, all these broad grounds which I have placed before your lordship, my lord. My lord, may kindly come to page 20, para 18. This is what is there. I'm reading from their offense report, para 18. This is where my name appears for the first time. My lord is there at para 18.
Yes.
Yes. That on-spot questioning Pramod Ray, Torun Kumar and Sujit Kumar, I am appearing for none of them, admitted that they were involved in the trafficking of ganja for monetary benefit. They brought the aforesaid ganja from Tripura in the said truck. They further admitted that the owner of the consignment are Afzal and Vichindra Ray. I am neither Afzal nor Vichindra Ray. And owner of the truck is Baiju Thakur. Yes, this is me, from Bihar. And the ganja was supplied by one person, namely Opu of Tripura. So the supplier is Opu. The owner of the ganja is Afzal and Vichindra Rai. And I am just the owner of the vehicle. That is what para 18, page 20 says, madam. Now, my lord, will kindly come to page 26, para 39. That's how I am implicated. Page 26, para 39. That all the 3 accused in their voluntary statement revealed that Afzal and Vichindra Rai is the receiver of the said ganja. One person, namely Opu, is the supplier of the same ganja, and the owner of the said track, Baiju Thakur, is also actively involved in the business. That is the solitary allegation against me. Now, my lord will see, they had also received their mobile number. This all mobile number detail is given, and my client Baiju Thakur's mobile number, the last one, my lord will see, 7011928956. My lord will kindly mark this mobile number because it has a bearing in this case, my lord. Now, my lord will see para 40 of the same, just the preceding para. I am reading 1, 2, 3, 4, the fifth line from bottom. Baiju Thakur, it starts with the word Baiju Thakur. My lord is there. Baiju Thakur mobile number. My lord may compare this mobile number with the mobile number at para 39. It is same, I have compared it. Is registered with the name of Kushal Kumar Jha. So the mobile number, we cannot connect the mobile number with Baiju Thakur. It is registered with Kushal Kumar Jha. So the only way to connect was to examine Kushal Kumar Jha. My lord will kindly come to page number 42. My lord will see, this is the list of witness. Nowhere the name of Kushal Kumar Jha figures. They don't examine or try to get hold of Kushal Kumar Jha, because that was the only connected link for, because they do not have my voice sample, voice record. These are all CDR. It is in the name of Kushal Kumar Jha. Now, my lord will kindly come to para 48, page 30. My lord is there. Page 38, para 48. That notice under 67 issued to Baiju Thakur such and such in both of his permanent and temporary address to appear to NCB office to record statement on such and such. Notice was issued, para 49. On 39/2020, Baiju Thakur appeared at NCB office to record statement. Yes, that is his conduct. He has voluntarily appeared. Now, my lord, what was seized from me? My seizure list, my lord will find at page number 48. This is the type copy, and the original one is at page number 51. This is the type copy. My lord may see the original also at page 51. No contraband, nothing whatsoever. Not even 0.001 milligram. These are all. My lord, this is not the seizure list of Baiju Thakur. This is seizure list of somebody else. No, my lord, this is not the seizure list of Baiju Thakur. This is the seizure list of the other three, Tarun Kumar and other, Pramod Rai and other. Baiju Thakur seizure list, my lord. This is the seizure list which shows that the ganjas were recovered from Tarun Kumar, Pramod Rai and the other Sujit Kumar. But I'll indicate the seizure list of seizure list showing, yes, Baiju Thakur seizure list is at page number 59. Page 59 is Baiju Thakur seizure list. What is recovered is a cash amount of 7,800 rupees. Yes, my lord. Now, my lord, on the last occasion, my lord, we could not furnish some documents, my lord, which, because my lord, my client is inside the jail, it is very difficult to even have proper instructions. Now, my lord, will kindly see, this vehicle was in fact sold by me at page number 53 is the sale deed, my lord will see.
Whether the vehicle was transferred from your name to the name
Yes,
of
my
other
lord,
person?
my lord, I don't know the procedure in the state of Bihar, but there is an affidavit, there is one form from the motor vehicle department, my lord.
No. My pointed query is
Yes.
clear.
Yes,
Whether on the date of commission of the offense, the vehicle stands in the name of the present accused or not?
present accused person, because there were some finance issues, some finance department issues. But my lord,
Then your argument is will not advance your case.
so, my lord, will, my lord, I'll please realize, because assuming that even I am an owner of the truck, their own document says that I am neither the receiver nor the supplier.
That's all right.
Now, my lord will see page 53 for a while. Now, my lord, this was in Hindi actually. We got it translated at page 55. My lord will see. This is a registered deed, page 55. Then, my lord will see. This is the form of notice transfer for ownership of a vehicle. Even that procedure are also done. Page number 57, my lord will see.
No, it will not help you in as much as on that day the vehicle was in your name.
Now, my lord, suppose, my lord, for the sake of argument, my lord, suppose, my lord, today I sell a vehicle, my vehicle to Mr. X, and I sign a sale deed, I sign the required transfer forms and what the prescribed transfer forms, my lord, and my lord, I deliver the possession of the vehicle. Now, this vehicle is found in connection with an offense after I sold it. My lord, only because the formalities in the office of the district transport office has not been complied with, do I become an accused in that case?
That is the law.
But I cannot be connected with the offense.
That is the law.
There might be some case under the Motor Vehicle Act. But, my lord, for an offense of such a nature, my lord, to connect him only based on this, my lord, in my respectful submission would be too harsh on his part, my lord. Now, my lord.
Then okay, you go and challenge the FIR, search it.
Now, my lord, I am getting it difficult to get a bail, my lord. Washing is a far reach cry, my lord. Now, my lord, PW1.
You can file the petition for granting you bail. You can file the petition challenging the FIR and the search it also.
Now, my lord, charge sheet, because, my lord, I am praying for, I am saying that I am not connected. Otherwise, on the merit of the charges, for the other person who have been arrested, my lord, I have nothing to say, my lord. Now, my lord, another thing your lordship will see. Till now, 3 PWs have been examined. PW 1 and 2. Page number 62 to page number 68.
They are the Caesar witness?
My lord, they are the officials of the NCB. There is no implication against me.
Yes, and nothing has
PW1,
been recovered from your position.
nothing has recovered from my position. No implication against me, not even a.
So unless and until the IO is examined here in this case, how can you say that there is no material against you?
Now, my lord, by the time the IO examined, 3.5 years, your lordship have given a direction, and I'll show how they are complying your lordship's order. My lord will see what your lordships on the last occasion while rejecting the bail, what your lordship has directed, and I'll show you from the record, my lord, what the rejection order your lordship will see at page number 102. Now, my lord will see kindly the date of this rejection order. My lord,
Yes.
see the date. The date is 16/12/2022.
Hmm.
Now, my lord, your lordship has found that
Yes.
sorry, I'll continue. Now, my lord, 16/12/2022,
Mm.
your lordship has rejected my bail prayer.
Mm.
Now, my lord, before I come to the grounds of rejection, I'll show what your lordship has ultimately indicated. Page number 107, para number 13.
Mm.
Accordingly, the instant petition stand dismissed. However, the learned court below is directed to expedite the trial and complete the same at the earliest possible time without being influenced by any of the observation made herein above, as the same is made only for the purpose of disposing the bail application, not merit of the case, and if necessary, recourse has to be taken under the provision of 309. Now, my lord, if I count correctly, it is 1 year, 1 month. This order is passed.
Mm.
And during this course of 1 year, 1 month, if your lordship asks me how many witnesses has been examined, 1.
Mm. So,
So, my lord-
who is responsible for
My
the
lord,
same?
responsible, my lord, my client is inside the jail. So my client by no stretch can be
No,
responsible
no,
for a
why
delay.
the witnesses could not be examined?
Now, my lord, some of the records, my lord, I have annexed with this. I'll just show, my lord.
Hmm. Whether the LCR was
Page
called for?
number, yes. It was there. Acidic LCR.
LCR was- It is a very good one. It is. Acha. Yes.
Yes. Now, my lord, will kindly see some of the dates I'll indicate, my lord. Page 70 of my petition. 11/1/2022.
Hmm.
No witness present today. Then 8/2/2022. This order extends till page 71. No witness present today.
Mr.
My lord.
Mr. Viswas,
My lord.
we have not called for the LCR. Now the
My lord, this application was filed in October, somewhere in October project.
pardon?
This application were filed somewhere in 7th of October. LCR was called for.
No, no, no. Only status report was called for. So given the nature of your argument, the LCR is necessary. We have to see who is responsible for this delay.
My lord will definitely, my lord, what has fallen from my lordship, I am not arguing that, my lord. My lord, by no stretch, my lord, by no way my client can be responsible for the delay because he is behind the bar. Every 15 days he has been, he is paraded from Lokra to
That's all right.
Aminganj.
That's all right. But we have to see who is responsible for the same. Whether the prosecution, whether the court. And to ascertain that LCR is necessary. And you know the judgment of this AR Antules case. There the delay, how delay has to be ascertained. The principle has been laid down therein.
My lord, subject to correction, my lord.
Hmm.
If I understand AR Antules case correctly, my lord,
Hmm.
AR Antules case is on quashing vis-a-vis delay. That whether a matter can be quashed because of inordinate delay, because before AR Antules case, one judgment Supreme Court said that inordinate delay is a ground for quashing. Now, my lord, in AR Antule was on bail. He was the Chief Minister of Maharashtra.
Hmm.
He was on bail.
Hmm.
Because he was on bail to
No, no, we are not on the factual metrics. We are on the law. How the delay has to be counted. There it has been explained.
My lord, I will place on more recent judgment of 2023,
Hmm.
where delay vis-a-vis bail is explained.
Hmm.
That is delay for the purpose of quashing Antules case, because an SLP, in fact, a writ petition was filed
Hmm.
urging that because of the inordinate delay, this man has to face a trial which is infringement of his Article 21.
Hmm.
There the Supreme Court has laid out. In Ever Antenna's case, my lord, the concept
Okay.
of bail was not there.
No,
Because he was
no,
already on
no,
bail.
no, the trial.
Trial.
You produce the judgment.
I have the, now if your lordship wants to call for the LCR, then
Yes,
again.
we will call for the LCR. Definitely,
My
we'll call for the
only-
LCR.
My only submission would be, my lord, since it is already October, November, December, there are more than 3 or 4 months, my lord, this bail is pending. My lord, will kindly give a date, my lord. Maybe within January, my lord.
Yes. Heard Mr. M. Biswas, a learned counsel for the petitioner, like accused, and also heard Mr. S.C. Kaya, learned standing counsel for the NCB. It appears from the record that though up-to-date status report was called for from the learned court below on 16/10/2023, the LCR has not been called for till date. Given the nature of argument advanced by Mr. Biswas, learned counsel for the accused, perusal of the case record is very much necessary, and accordingly it is provided that registry shall call for the scanned copy of the record from the learned court below, fixing the matter on 38:30.
Lordship, on 30th, I'll be out of session. Lordship, maybe on 2nd of February.
No, thereafter you will come and you will argue that already 3 months, 4 months elapsed.
No,
So
then
that is not.
fixed on 25th.
Pardon?
25th.
25th.
Lordship.
Okay, 25th.
My lord, can it be 24th or 29?
29 and 30, Lordship, I'll be out of session.
Okay, my lord, I'll have 25th, let it be.
Okay, 25th. And this A.R. Antula's judgment, you bring it, and the recent judgment of Supreme Court. So what was the allegation?
Allegation,
Is it a certificate case?
yes, Lordship, solicited. Trial begins, Lordship. There are altogether 11 witnesses are there, where 3 witnesses are examined, Lordship.
All total?
11 witnesses. From them, three of them examined, Lordship. Page number 27 to 34, Lordship.
Yes.
Lordship, PW1, page number 28, where states that reasonable my petitioner as driver, Lordship. But and another PW2 states that, and page number 30, Lordship, possible another co-accused, Lordship, possible as driver. So, and PW3 at page number 33, para 8, Lordship, where PW3 states that driver is Hasibul, Lordship. So here the petitioner is implicated, Lordship, and he was arrested from home, Lordship, from his house, Lordship, Hasila Bill. Facts are not corroborating, Lordship.
What was the quantity?
Quantity, Lordship.
Commercial quantity?
The 5,000 bottle cough syrup.
Cough syrup.
5,000.
Total.
Not report from the petitioner, Lordship, from his possession, from the truck, Lordship.
Truck was driven by you?
No, Lordship, possible. Another co-accused, Lordship.
Oh, who are you then?
I am reasonable, Lordship.
You were the handyman?
I'm not. I'm here. I'm implicated, Lordship, by the co-accused.
Co-accused. So, where is the search sheet?
Search it at page 14.
14.
14.
Which is the relevant federal relating to you?
Number 14, Lordship, from whom or where recover or seized. Here is stated as from the possession of Hasibul Islam, son of late Hamdu Mia village, Sutdanga, PS Mankasa district, South Salman, Lordship, and Rizabul Haq. But Lordship, if Lordship go through the petitioner statement, where they are examined, Lordship, PW1 states, PW1 page number 28, Lordship. PW1 is the SI. He states that Rizabul Haq was driving the vehicle, where PW2 Azhar Ali, one PDB secretary, at page number 30, Lordship, where he stated the witness, where he stated that none other than the driver of the truck was apprehended by, no other than the driver of the truck was apprehended by police. I do not remember the name of the driver, but he is present today in the courtroom. The witness has identified accused Hasibul Islam as the said driver. And he didn't say anything for accused Rizabul. Also PW3, the SI, at page number 33, Lordship. Para 8. Before lodging of the Azahar, I interrogated accused Hasibul, in course of which he disclosed that he had procured the seized cough syrup from accused Rizabul. I, along with my staff, then apprehended accused Rizabul from his house located at Hasila Bill. So he was not in the trap, Lordship, according to PW3. So he was implicated, Lordship, by the courtiers and the arresting authority. Prisoner has no past criminal record, Lordship. He has family, parents, and family, Lordship, having a wife and a minor daughter, Lordship. The Lordship may consider his bail application, Lordship.
Yes, Borba?
Out of 11 witnesses, Lordship, 5 witnesses have already been examined, Lordship.
5.
And last PW5 was examined on, my Lord, 5/12/2023, Lordship. And there are material, my Lord, already has come during the evidence, Lordship. And because of 37 will come, Lordship. Because it's a commercial quantity.
Not from his possession, Lordship, from the truck. And the truck was driven
Oh,
by.
who is witness has implicated him?
The PW1, Lordship, may kindly peruse.
PW1.
Of page 27, Lordship.
Yes. Rizabul Haq is the driver of the vehicle, as per evidence of PW1.
As per PW1, Lordship. But PW2 denies. And PW3 states that he was not in the truck. He was arrested from home. Affidavit. The contradiction is there, Lordship. And he is behind a bar approximately 1 year and 4 months. Lordship. These are the star witnesses, Lordship. Lordship may notice one thing also, where PW1 states that para 2, we intercepted the vehicle and searched it. We recovered 5,000 bottles of cough syrup from the carrier part of the vehicle. 2 VDP members, namely such we had already called. We then brought the vehicle and then seized cough syrup to the Thana along with the driver and handyman of the truck, where PW2 states that para 1, Lordship, 1, 2, 3. 5 number 5th line. I accordingly went there at that very night and found a truck parked on the roadside. Police then brought me along with the driver of the truck and a number of packets to the Golpara Thana. Police then opened those packets at the Thana and I found the same to contain many bottles of cough syrup. So here it is stated the driver of the police brought me along with the driver of the truck and the number of packets. Charge was not happened at the Thana, Lordship, but carried to the Thana.
So these are the contradiction in the version of the witnesses which are to be looked into by the trial court at the end of trial. Can this court, while dealing with the bail application, can examine such contradiction?
It was in my notice, so I placed it before the Lordship.
Purva, apparently some contradictions are there in the version of the witness.
Question is that whether at this stage, Lordship, this honorable court will go through these all contradictions.
Lordship, 1 year already.
Only
done,
the
Lordship.
prima facie materials are there or not in the evidence that this honorable court will look into, Lordship. Only prima facie materials. Because there may be some contradiction, Lordship. My lord mentioned all this or give any findings.
Heard, madam? A Begum,
T Begum, Lordship.
T Begum,
Tasmina Begum.
Tasmina Begum, learned counsel for the accused, and also heard Mr. Borwa, learned additional pitch for the state respondent. Argument concluded, order is at
But this decision is behind the bar for 1 year already, Lordship. What you consider this?
So how many witnesses cited? Total 11.
11, Lordship.
Out of 11, 5
Next
have been
week.
examined.
And the 3 witnesses are star witnesses, Lordship, and the chairperson was, when the chairperson was happened, they are there, Lordship.
Yes. Next,
And number 17.
none appears for the accused on call. Lays the matter after 1 week.
Item 18.
My pleasure. Total custody, Your Lordship, 179 days, Your Lordship.
Hundred and
79 days.
yes. So it is a solicited case.
Search.
How many witnesses examined till?
My lord,
Nothing
not examined.
No trial begin, Your Lordship.
Actually,
No
my lord,
suspect,
for
no-
appearance, for production and appearance only, my lord. On the last day, date, my lord, the order is there, my lord, of 1812, my lord.
1812.
Charge is yet to frame, my lord, victim not examined. No.
On 31st August, Your Lordship, search is submitted, Your Lordship. After that, Your Lordship, no search frame, no cognizance, Your Lordship, only production, Your Lordship. There are other 3 accused persons.
Where,
All are
in which
absconded,
court this case is pending now?
Lordship.
Where it is pending?
Dubri, Your Lordship, special judge.
Special judge of should.
Total 4 accused person, Your Lordship. Other 3 are absconding, Your Lordship. When the petitioner was arrested, Your Lordship, subsequently charges submitted. He was arrested on 23rd July, Your Lordship.
So some of the co-accused have not yet appeared before the court below. That's why the case is pending. Prima facie materials are there against him for the offense under section 6 of the POCSO Act and also so 471. So let the search frame against him.
Lordship, the birth certificate of the victim not produced, only school certificate produced. To put
Yes.
that trial court, your lordship, and medical, I think there is no. there was a
Medically
medical-
done after some time, after 15.
There is no medical report, your lordship, in the record, your lordship, I think.
Soma, have you gone through this
Yes,
medical?
my lord, I have gone through my lord.
Is available here.
My lord,
Medical report is available in the case record.
report, I think, my lord, real report, I think not.
Not
there.
available.
Yes, I have flag mark, my lord, 164 is there. And
Hmm.
some witnesses of the neighbors are
Parts-
there.
Birth certificate also not enclosed, your lordship. Is of the victim is so uncertain.
No, if birth certificate is not available, then this school certificate will serve the purpose.
Yes.
But further custody, your lordship.
Huh?
The charge is not framed, my victim is not examined yet at this
Mhm.
stage.
If medical available, your lordship, medical may kindly call for your lordship. If any, your lordship.
Sharma, you examine the record,
I
whether
have
medical
examined-
is available here,
My lord,
and you see the search sheet whether she was medically examined or not.
my lord, my lord, for few.
Okay. Probably this record, maybe give me to me.
I check your lordship tells no.
Okay, as agreed by learned advocates of both sides, release the matter in the second week of February.
My lord. Some progress may be there.
And if the medical report is not available, we'll call for the medical report also. If it is not available.
Yes. I will examine.
Sharma, you examine
My
the
lord, my
record
lord.
and
I will
let me know.
examine and report. my lord.
Okay.
Item number 19,
Date your lordship, second.
second week of February, on 13. On 13.
Oblige your lordship.
Item 19.
Here in this case, records were called probably records not received.
Not received.
Progress is not showing.
No, they stepped in. কি কৰি থাকে ইহঁতৰ মানুহকেইটা Office note dated 11/1/2024 indicates that scanned copy of the record has not yet been received. Accordingly, it is provided that Registrar shall call for the scanned copy of the record from the learned court below, fixing the matter on when?
On 30.
From which court?
On Coimbatore. Can it be on 6th, Lordship?
Karimganj,
Yes. Can it be on
6th of February. Okay.
Item 20.
Lordship, this petitioner lordship was arrested on lordship 4/12 and forwarded on 5/12. As of today, lordship 45 days in custody. Lordship will find.
45 days.
Yes, lordship. First, you will find the FIR at page 10, lordship. And Naka was set up, lordship. And the highway, lordship, and 2 persons were apprehended, lordship. And among them, lordship, one is the petitioner, lordship. And from
Who
them,
is the petitioner?
yes, lordship.
Who is the petitioner?
Nazrul Islam, lordship.
From whose custody in the
Both,
contraband
as
were
per
recovered?
the FIR, lordship, it is from both the apprehended persons, lordship. 5.48 grams, lordship, of suspected brown sugar.
A small quantity,
It's not small quantity, lordship. It's
intermediate quantity.
intermediate,
What is the small quantity?
small quantity, I think.
Or
5 grams.
5 gram. So what is the stage of investigation?
Only pending for the FSL report.
Rest of the investigation
Not
completed.
completed.
So, okay, heard Mr.
M. Ahmed.
M. Ahmed, learned counsel for the accused, and also heard Mr. Borua, RJ Borua, learned additional PP for the state respondent. This application under section 439 services preferred by accused Nazrul Islam, who has been languishing in jail in connection with Dhula PS case number 256 of 2023 under section 21B 29 of the NDPS Act for granting bail. It is to be noted here that above noted case has been registered on the basis of an FIR lodged by SI Madan Newar of Dhula PS on 4/12/2023. The essence of allegation made in the FIR dated so and so is that acting on a tip of he along with police staff intercepted 2 persons now apprehended Sukur Ali and Nazrul Islam and recovered 5.48 grams of suspected heroin.
Brown sugar.
Suspected brown sugar from their possession and seized the same preparing scissors. The learned counsel for the accused submits that the accused is behind the bar for last 45 days. And the quantity of contraband substance recovered allegedly recovered from the position is of 5.48 grams, which is of intermediate quantity, and that the accused is ready to cooperate with the investigation. No investigating agency, and therefore it is contended to allow the petition. On the other hand, Mr. Arja Borua, learned additional PP, submits that he has received the case diary, and the same indicates that material part of the investigation is over, and the case is pending for collection of FSL report only. Having heard the submission of learned advocates of both sides, I have gone through the petition and the documents placed on record, and also produced the case diary with the assistance of Mr. Borua, learned additional PP. Indisputably, the accused was arrested on 5/12/2023, and since then he has been languishing in jail for last 45 days. Indisputably, also the quantity of contraband substance allegedly recovered from the possession of the accused is 5.48 gram, which is of intermediate quantity. And as such, the embargo under Section 37 of the NDPS Act will not come into play here in this case. Further, the case diary indicates that the material part of the investigation is almost over, and the case is pending for collection of FSL report only. Having considered above, especially the nature and gravity of the offense and the period of detention, and balancing the same with the nature and gravity of the offense, this court is inclined to allow this petition. It is provided that on furnishing a bond of rupees 50,000 with one surety of like amount to the satisfaction of the learned
Special judge.
special judge NDPS Act, Dorong, Mangaldoi, the accused be enlarged on bail. Case diary be returned.
I oblige.
Item number 56.
Lordship may be allowed to withdraw lordship.
Pardon?
May be allowed to withdraw lordship.
Withdraw. Why?
93 days or so. 93 days.
Lordship, I am not pressing in the matter.
Probably, but he has been granted default bail.
By the court
Today
bail.
is 93 days.
Acha. Miss, your good name?
J. Akhtar lordship.
Z?
J. Akhtar.
J after learned counsel for the applicant submits that she has the instruction to withdraw this application. Accordingly, PR is allowed. This application is disposed of on withdrawal.
57.
Lordship, for 39 application, today is 42 days, Lordship. Section Lordship, 547, 380, 409. FIR phase 9, Lord.
Borua, you received the case diary?
Case diary not received.
Not received.
Today is 33rd day, Lordship. The FIR phase, Lordship.
This is regarding stealing of this motorcycle.
Motorcycle, Lordship. The accused is residing in the informant's house, Lordship. Then negative, Lordship.
Borua, what to do?
No, that day also, this matter was hard, Lordship.
Pardon?
Earlier,
Earlier occasions, so Lordship has hard this matter, Lordship, probably.
Yes.
But without the case diary, Lordship, my lord, I leave it to your Lordship, my lord.
Pardon?
I leave it to your Lordship, my lord, since we have not received the case diary, my lord.
That's all right, but perusal of the case diary is necessary.
It is necessary, Lordship. Or we can, my lord, fix it on, my lord, short date, Monday or next Monday, then.
Okay, Monday. Mr. RJ Borua, learned additional PP, submits that he has not received the case diary. Having considered the submission of learned additional PP and also considering the nature and gravity of the offense, perusal of the case diary is found to be necessary, and it is provided, and last opportunity is afforded to Mr. Borua to produce the case diary on Monday.
58.
You're supposed to be content.
2 p.m. At 2 p.m. then.
59.
May I please, your lordship? This
Yes.
is a 413 application, my lord. I am arrested, my lord. 23/12, my lord. Today is 27 days in custody, my lord. And I am the registered buyer, my lord, through a sale deed, my lord. And I have purchased it on bona fide belief, my lord. And the lordship can see the FIR at my lord. Page 21, my lord. We are the developers, my lord. My company has purchased it from the power of attorney holders in Nogen Gogoi. Sorry, my lord. Devojit Nath, my lord. Paragraph 3, my lord, page 22, my lord.
Page number
Page 22, my lord, paragraph 3.
28. What is 28?
28, 20, type copy, my lord. Type copy, my lord. Type copy starts from 21, my lord.
So you purchase it from Nogen Gogoi,
Yeah.
who is the
Dev-
power of
Devojit
attorney
Nath,
holder.
I have purchased it from Devojit Nath, my lord. He is the power of attorney holder. He sold it to our company, my lord. Page 36 is the power of attorney.
What is who is this Nogen Gogoi
Nogen Gogoi is the owner, my lord.
of that plot of land?
Yes, ma'am. And there is one more informant they are the owners, two owners, my lord. They have executed a power of attorney to Mr. Devojit Nath. And we have purchased it in long before, my lord, from Devojit Nath, but we have not given any possession of the land. Though there is a sale deed. Lordship will find at page 45 is the sale deed. Registered sale deed on our behalf, my lord. Page 45 is the sale deed. Start from 43, my lord. We have purchased it on 2nd July 2022, my lord. Thereafter, as the possession was not given to us, we have initiated a title suit, my lord, page 53. In the civil judge, it is pending, my lord. In filing date is 27/2023, my lord.
Where it is pending? Civil Judge, Senior Division,
Yes, my lord.
Guwahati.
Guwahati, my lord. Page 53, my lord. And the informant has been made the opposite parties also. Lordship will find PS 54. Petitioner is the Lordship will find petitioner and the advocate Balaji Developers, respondent advocate Debojit Nath, Sri Gagan Gogoi, and Punna Prabha Hazarika. Punna Prabha Hazarika is the informant, my lord, in this case. This is the basic case, my lord. Now they are alleging this informant that they never executed this power of attorney. And in the meantime, Lordship kindly see page 58. From whom we have purchased the land, my lord. He was granted absolute interim, absolute pre-arrest bail, my lord, after perusing the case that 23/8/23. Deposit Nath.
Yes, on the other day, your contention was that 41A notice
Yes,
was not
Lordship-
given to you.
Lordship is absolutely correct, my lord. Lordship kindly see the forwarding report, my lord.
No, it was not mentioned in the forwarding report. That's why the case diary was
Yes.
called for.
No forwarding.
Yes, Mr. Borwa, is there anything in case diary?
My lord, materials are there also. My lord, only my investigation is going on. My lord, one Punna Prabha Hazarika and one Gagan Gogoi.
Hmm.
They are the absolute owner of a plot of land around, my lord, 2 biga, 2 katha, 10 lesser.
Hmm.
Now this, my lord, Debojit Nath lordship. In my lord, connivance with the my lord, register office lordship and other person lordship, they one my lord, false power of attorney was executed in his favor lordship. That is also commission basis lordship. By forging the signature of the my lord, original Pattadar landholder and my lord, forging them, even forging the my lord, PAN card, my lord. Now, by virtue of that power of attorney lordship, he sold the land to this petitioner lordship, petitioner's farm. Now, the investigation, it is not my lord, clear, very clear that my lord, whether it is knowingly they purchase or unknowingly they purchase lordship. But my lord, both the deeds are fake lordship.
Both the?
Both the deeds are fake lordship. Even the my lord, power of attorney also fake, and by virtue of that power of attorney, he executed another sale deed in favor of the company of the my lord, this petitioner lordship.
But his statement is recorded.
Statement recorded, he said that we do not know anything, my lord. We have purchased the land from this person lordship.
No, whether there is any indication regarding compliance of 41A notice?
That is not mentioned lordship in the case diary.
Okay, we'll see.
My lord.
We'll pass the order after perusing the case diary.
Case 32, my lord, lordship. In the forwarding, my lord, there is no mention.
No, on the other day you have pointed this out.
Yes, yes.
There is nothing in the
Forwarding.
forwarding report
Absolutely
regarding
nothing.
compliance of that.
That is the requirement of the law, lordship knows my lord very well. Lordship also passed several judgment to that point, my lord. Neither they have indicated why they have not issued the notice. Neither they have indicated in the forwarding report why I have been arrested, mandatory requirements as per the Harnesh Kumar judgment. Both are not complied with, my lord.
And initially also the case was registered under section 420, 416, 471. Later on 409 and 120 was added, has been added.
After our arrest,
My lord.
after our arrest, no one.
So you have been arrested on, who is that?
My lord, arrested on my lord
22, my lord.
22/12.
12.
And my lord, in the forwarding report, there is no mention of the 409, my lord. Lordship kindly see forwarding report, there is no mention.
No, that's why
Subsequent-
when the
409
section
was
409 was added.
Yeah, but so when in the forwarding report, there is no mention, my lord. At that time, there is no, it was a subsequent development, my lord. Just to bypass this probably, my lord. Where is the question of 409? Here, my lord. Misappropriation, my lord. It was. a
So
case of a-
it may not be applicable in his case, but there may be some connivance with the public officials.
Yes, my lord.
That's why
That's a
section
different- But at
409.
the time, 409 was not there, man, in my forwarding report. So the mandatory
Okay,
requirement,
after going to the record, he will let this court know about the same and will pass the order
It is after the arrest, no, no, so it is
after his arrest.
after the-
You submit the case.
My lord.
and we are not named in the,
FIR.
officials are not named in the FIR,
My lord, that part is not clear, Lordship, whether they have, my lord, knowingly purchased or unknowingly purchased, Lordship, but otherwise,
why
Lordship, both the deeds are fake, Lordship, and
That is,
forced.
that is why, my lord, we have gone for the civil court and we are the first person, my lord, to initiate the civil proceeding, my lord. As because the sale deed was executed, but no possession was handed over, then we have approached the civil court and they have also appeared, the informant also appeared in the civil court. But after 1 year, my lord, this FIR has been filed. Now we have been arrested, but the person from whom we have purchased, he was only enlarged on anticipatory bail, my lord.
This is
Why our
very-
custodial detention is necessary?
Wait, please, Your Lordship. My lord, I may be excused, my lord. I mentioned item number 51, my lord. My lord, it is a part hard matter. It will take only 10 minutes time, my lord. I will cite some decisions only. And,
Mr. Sheikh, we will hear you.
my lord.
First, let us
At-
complete
as-
the other
at-
matters.
At least as a last item, my lord. 3 times it was listed, my lord, but it.
No, today we will hear it by anyway.
Oblige, Your Lordship.
Lordship, regarding Lordship, I beg indulgence, Lordship, regarding item number 37, Lordship, case diary is not there, Lordship. I am not on interim, Lordship. Let the case diary be called for, Lordship, for second week of February, Lordship.
On the pair being made by Mr. B. Kodori, learned counsel for the
37,
applicant,
37.
lays the matter on.
On 5/2/24,
Second week of February.
second week of February,
Okay.
9/2/24.
On that day, learned additional PP shall produce the case diary before this court.
Highly obliged.
Yes.
Item number,
I am not getting you.
My lord, in respect of item number 57, Lordship.
Ah.
That is already over, Lordship. My lord, that person is behind the bar from last 43 days, Lordship. Lordship has called for a case diary on fixing 22/1/2024, Lordship.
57.
57, Lordship.
Ah.
My lord, last now we have got the information, Lordship, the FR has been submitted, Lordship.
FR.
FR. So, my lord, only my prayer is, my lord, putting this person, my lord, behind the bar. Person can, my lord, pass necessary order with him. The FR has been submitted. But he
Who
is
is
not there. I have
Mr.
searched him, Lordship. I have not found the counsel for the petitioner.
Okay, you call that person.
I'll call.
And areas.
Item number 58 by video conferencing.
May I, Lordship, please? May I,
Yes.
Lordship already, Lordship has substantially heard the matter. All accused persons were, co-accused were on bail, Your Lordship, by this honorable court. So therefore, the law parity is there, if Your Lordship kindly consider. I am in the bar, behind the bar, Your Lordship, since 12/12/2023, 37 days as on today, Your Lordship. Beside
Yeah.
making all the submission on merit also, I'm behind the bar, Lordship, on the basis of a statement of a co-accused. The Lordship is aware that how much the co-accused statement is relevant at the trial, Your Lordship. Beside this, Your Lordship, there is no materials against me. I am an advocate. I am doing some works, and therefore they are on suspicion, Your Lordship. On the basis of that statement, I am arrested. And therefore, I also placed one judgment of 2019, volume 16 HCC 547. And another 2019 Lordship.
So
will
how
find
this judgment will help you?
Here, the Supreme Court has laid down that the statement of a co-accused, unless there is some other material, is hid by section 162. Therefore, it cannot be relied upon. That is in paragraph number 41 of the judgment. And my arrest solely based on statement of a Moinul Haq. There is no dispute between the bar, Your Lordship.
Which paragraph you have relied upon in this judgment?
Paragraph 41, Lordship, kindly first see.
Para 14.
41 in 2019 judgment. Para 41, Lordship.
Yes.
Thus is quite clear a person who stands in the shoes of accused being named in the first information report can be examined by the police officer under section 161 CRPC. There is no bar. The next question, however, as to whether the statement given by a person who stands in the shoes of an accused and who gives a statement, whether the statement is admissible in law. It is here that the section 162 of the code comes into play. Therefore, it has only, Lordship, is a mere statement be not to be used in the trial. Lordship, then please comes to paragraph 42. In paragraph 42,
yes,
there is a reference of 3 judges bench of the Supreme Court, wherein says that that statement is hid by section 162. Except the exception is section 32, Your Lordship. And the finding in Lordship will find in paragraph 43 and 44. 43 and 44, Lordship.
Yes.
So that statement, so for my admission is, if anything there, it is hid by section article 23 of the Constitution of India. And 44 says that unless there is some other materials connected with the offense, the statement of an co-accused who are on the same footing with me has no relevancy in the framing of charge. And above all, Lordship, I am on the parity also. All co-accused person, as Lordship aware, they all go on bail. And lastly, one Mr. Behrul Islam Khan, he was also allowed to go on by a coordinate bench of this Honorable Court on 22 of this month, Your Lordship. Moinul Haq, Your Lordship, kindly take a note that the Moinul Haq, who is the manufacturer of this mutation order, he was also allowed to go on bail after being arrested. Because Lordship will find in the FIR at page 14 that Moinul Haq is the main culprit who has manufactured this. Page 14, Lordship will find the FIR wherein Lordship will find page 16, Lordship will find. Second paragraph from bottom, 4 lines. Advocate Moinul Haq, mutation order is passed in Moidium Bibi case, was prepared by Advocate Moinul Haq. He has prepared with the assistance of the Lat Mondal and etc. That is the allegation. Lat Mondal also allowed to go on bail, Your Lordship. Moinul Haq also allowed bail on. So Lordship, kindly consider on parity, Your Lordship. And I am 37 days in the judicial custody. Only on the basis of a statement by a co-accused, that is Moinul Haq. I am also an advocate, Your Lordship, also consider that aspect also. There is no flight risk, Your Lordship, being I am the permanent resident of Guwahati and also an advocate on roll. So there is no flight risk.
Yes, Mr. Borua, is there any evidence except the statement of the co-accused?
On the co-accused statement and Lordship, he has also, my Lord, stated Lordship, as Lordship has, my Lord, what rejecting the, my Lord, this earlier bail application, Lordship, page 24, Lordship.
That Lordship, has, I am already pointed out.
The second bail application, Lordship. Page 24 is the earlier rejection order.
Yes.
Lordship has might not mention that what is the ground of rejection Lordship. He has done some mutation work Lordship in the circle office.
So that's all right, except the statement of the co-accused, is there any other material against him?
Any other matter specific materials are not there Lordship that he has might not connivance with some other land broker Lordship he has done it. But Lordship in the mutation case Lordship he has done the mutation work Lordship and some work before the circle officer also. Circle office also. Lordship.
That is revealed from the co-accused statement, Your Lordship. That is revealed. There is no materials that I was present and I am doing something. It is Latmundal and Moinul law.
Okay, Borwa, you submit the case diary.
My lord.
Okay, we'll pass the order.
Lordship, I am grateful, Your Lordship. Kindly consider. I am in 37 days. Lordship, I am grateful, Your Lordship. I am grateful.
Number 23. 23, Delhi hearing.
Yes, my lord, 23, we have not received the case diary Lordship, but we have received an information Lordship. Yes, my lord, due to some law and order duty Lordship, the IO could not forward the case diary.
Okay,
The
Mr.
other co-accused, Your Lordship, has
RJ Borwa learned additional PP submits that he has not received the case diary. And prays for granting him some more time. Here is accordingly allowed. So list the matter on when?
9 February. Lord.
9th of February. Till then, interim order dated 24/8/2023 shall continue.
All right.
Four 38 applications Lordship. FIR at page 10 Lordship. 25. Page 10, annexer 1.
Whether notice was served upon the respondent?
Serve or not
Lordship. Kindly see the flag Y Lordship. Flag Y Lordship. On 7/12/23 Lordship. It was shown to have been delivered but not returned back to the court Lordship, but it was shown to have delivered 7/12/23 and case is pending Lordship since September 2023 Lordship.
So he uses his money.
Where is the postal receipt of issuing notice?
Yeah.
Postal receipt. This is the tracking
Yes, Lordship,
record.
not returned back Lordship. Acknowledgement not returned back. AD card not returned.
No, that's all right. But the postal receipt of sending this consignment. This is the track record.
Yes, I am on the basis of track record Lordship. 7/12.
No, you have sent it by registered post, right? Where is that postal receipt?
We have taken steps twice Lordship.
No, postal receipt to
Yes, Lordship. That is perhaps in
No,
the
no.
court.
Or whether that receipt is available with you.
Not with me Lordship.
Then how can we say that
That is
this
office note.
consignment
Office
was?
note, it is reflected in the office note also. In office note dated 9/10/23 and 23/11/23. In office note. Lordship. 9/10/23 and 23/11/23.
Okay. Probably আছে কিন্তু ছেভেন টুৱেলভ এইটো ডেলিভাৰী হোৱা বুলি কৈছে ডেলিভাৰ এইটো হেৰিটো ইয়াৰ লগত কানেক্ট কেনেকে হ'ব গৈ পেলাই এইটো কনচাইনমেণ্ট নাম্বাৰটো ইয়াতে পোষ্টেল ৰিচিপ্টটো ক'ত ইয়াতে এইটো যদি কৰা নাই আমি কেনেকে ধৰিম এতিয়া এইটো হেৰি হৈছে বুলি ৰিচিপ্ট দেখাই ডেলিভাৰী পষ্টহে লগাই দিয়ে নহয় সেইটো ঠিকে আছে এতিয়া পঠালো পঠোৱাৰ লগে লগে এটা নাম্বাৰ দিব ন এটা নাম্বাৰ সেই নাম্বাৰটো ক'ত ইয়াতে সেই নাম্বাৰটোৱে এইটো নাম্বাৰ হ'ব লাগিব যোনটো এইটো এই নাম্বাৰটো পঠোৱাটো হেৰিটো ক'ত ইয়াতে নোটত কিবা ৰিফ্লেক্ট কৰিছে নেকি ট্ৰেকিং ডিটেইল ডিটেইলটো আছে চাৰ্ভিচৰ পৰা আহে নেকি এই চাৰ্ভিচৰ পৰাটো Mr. Sarkar, would you follow that when you send one parcel, you have been issued one receipt, and that receipt number and the consignment number has to be same.
Yes.
Here, tracking details is available here, but it cannot be linked with the notice issued to him. So that if that postal receipt is available, then we can say that yes, this is the consignment number.
Right now, Lordship postal receipt not with me, which is part of my clerk. But Lordship, we have taken steps twice, Lordship. We have taken steps twice.
Yes, Borua, you received the case ID?
If the receipt, Lordship.
So, what is the stage of investigation?
When police is searching him, Lordship. Otherwise, 164 statement has been recorded, but some medical also done, Lordship. And witnesses are examined. And 164 statement, Lordship.
That is available with you?
Victim guard is implicated.
Can I see the?
My lord.
Lordship, this affair has been filed, Lordship, after 5 days of the date of occurrence, Lordship. And Lordship, out of Lordship transaction, Lordship, this affair has been filed, Lordship. And they are relatives, Lordship.
সেকশনত আহি যায় যেতিয়া আহি যায় ৰেকৰ্ডত টেক কৰি দিয়ে অফিচ নোটত ডেটটো অহা নাই বুলি কৈছে মই চেক কৰিব কৈছোঁ সেইখন আহি গ'লে টেক কৰি দিয়ে
কবি এইটো ক'ত আছে এইটো
এইখন হৈ আহে তেনেকুৱা টেকনলজিখন স্পীড পোষ্টৰ টেকনলজিখন
নহয় নহয় ৰিচিপ্টটো
ৰিচিপ্টখন ইমিডিয়েট নাহে ডেলিভাৰী কৰে তাৰপিছত পোষ্ট অফিচ
নহয় 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 এই যে নাম্বাৰটো দিয়ে ন
সেই যোনখন ৰিচিপ্ট ইমিডিয়েট নাহে
নাই মই ধৰক আজি এটা কনচাইনমেণ্ট পঠাব লগে লগে ইহঁতে এটা ৰিচিপ্ট দি দিয়ে এইটো ক'লে পঠাইছো তাতে নাম্বাৰটো থাকে আৰু সেইটো নাম্বাৰটো ট্ৰেক কৰিলে এইটো চাই নহয় সিহঁতে বুজি পোৱা নাই Yes, Mr. Sarkar.
Lordship, and from the FIR, Lordship, there is no explanation, Lordship, in respect of the delay of filing FIR, Lordship. 5 days delay, Lordship. Kindly see that.
Maybe
Occurrence took place on 22/7. And FIR 27, Lordship, in such a serious case, Lordship, the allegation is serious. Even then, they took 5 days time, Lordship. That too, they have not really explained in the FIR, Lordship. So these are the delays. Okay, actually, what happened, Lordship, there is a transaction, Lordship, between the petitioner and the informant. When he pressurized to refund the money then, and both are relatives, Lordship. And FIR itself stated that he is suffering from financial crisis, Lordship. He himself stated, the informant, Lordship. And he is 10 years, Lordship, they are relative, Lordship. So, and Lordship, case is investigated from last couple of months, Lordship. Custodial intervention may not be required.
between whom the financial transaction was there?
Due to Lordship, second line, Lordship, in affair, with due respect, restricted my daughter Miss Mirza Sultana Parvin is about 10 years. Due to my poor financial condition, has been living with her maternal grandfather, nameless family.
No, was there any financial transaction between the accused and the informant?
Yes, Lordship.
Where
Only-
it is mentioned?
Para 7 of my petition, Lordship.
No, any other material? That is your statement.
Yes, Lordship. No evidence, Lordship. We have no any evidence to show,
Then-
Lordship.
then-
But on a bona fide belief among the relatives, Lordship, between the relatives.
Heard Mr. A.T. Sarkar, learned counsel for the applicant, and also heard Mr. Arjay Borua, learned additional PP for the state respondent. Apprehending arrest in connection with Kazegaon PS case number 59 of 2023 under section 448 376 within bracket AB struck 511 IPC reduced section 18 of the POCSO Act. This application under section 438 services prepared by applicant Nazrul Haq for grant of previous pay. The above noted case has been registered on the basis of one FIR lodged by one Moinul Haq on 27/7/2023. The essence of allegation made in the aforesaid FIR dated so and so is that on 22/7/2023, his daughter Simoti X between bracket 11 years was in the house of her maternal uncle Mohammad Samsul Ali, and at about 7:30 AM when Nazrul Haq taking the sons of absence of family members entered into the house of Mohammad Samsul Ali and attempted to commit rape upon his daughter. But somehow she managed to escape. Mr. Sarkar, learned counsel for the applicant, submits that there is delay of 5 days in lodging the FIR and no explanation is offered in the FIR regarding the delay, and that there was financial transaction between the informant and the accused, and whenever the accused exert pressure upon the informant to pay the sum which he is entitled to, then the informant has falsely lodged this FIR against the applicant, and that he is ready to cooperate with the investigating agency. And his custodial interrogation may not be required in the interest of investigation, and therefore it is contended to allow this petition. On the other hand, Mr. R.J. Barua, learned additional PP, has opposed the petition. Full stop. Producing the case study before this court, Mr. Barua submits that the IO has collected sufficient incriminating materials against the accused, and the offenses are serious in nature, and therefore it is contended to dismiss the petition. Having heard the submission of learned advocates of both sides, I have gone through the petition and the documents placed on record, and also produced the case diary with the assistance of Mr. Barua, learned additional PP. It appears that the case diary indicates the case diary indicates that the IO has collected sufficient incriminating materials against the applicant. Having perused the statement of the victim guard recorded under Section 164 CRPC as well as under Section 161 CRPC, this court is of the view that this is not a fit case where the privilege of periodic bail can be granted at this stage. Then accordingly, the petition stands dismissed. Case diary be returned.
Item 26.
May I please the motion?
Yes.
Madam, 26, we have not received the case diary.
Pardon?
26, we have not received the case diary.
But as per my information, my lord, charge sheet is already laid. Petitioner is on interim after appearing, charge sheet is laid.
When?
Yeah,
When charge sheet was submitted?
about 15 days back, my lord, but the exact date is not me, my lord.
Okay, let him obtain instruction.
Monday.
Mr. Barua, learned additional PP, submits that he has not received the case diary and press for granting him some more time. Pair is allowed. List the matter on Monday.
Item number 28.
May I please your lordship. This is 438 application lordships. Matter pertains to lordship transportation of cattle lordship. Petitioner before your lordship is the owner of the vehicle lordships. The second bail application lordships, earlier it was rejected lordships. On the ground that it was investigation of very nation state lordships. Now
On the ground of?
the ground of investigation of very nation state lordships. Now we have annexed the cattle parcel received lordships. So who is the owner of the cattle lordships? I annexed a page, your lordship may kindly see. Page 16 onwards lordships.
You are the owner of the cattle.
No, I am owner of the vehicle only lordships. Earlier lordships, the cattle parcel was not there lordships. I am the owner of the vehicle lordships only. Mobile lordships, the state vehicle was also granted Jimma by the Lanet Court below lordships. Vehicle registration certificate, your lordship will find it page 34.
Yes, Borwa?
My lord, we have received the case diary, lordship. From the, my lord, case diary, my lord, a truck was intercepted, lordship, and from the truck, 24 numbers of, my lord, cattle was recovered, lordship. The driver and handyman, they fled away, lordship. It is the, my lord, material before in the case diary, lordship. Now, who is owner and nothing has been mentioned, lordship. Let him appear before the IO, lordship, along with the documents. I will verify and call for the absolute case diary.
One Sabiqul Islam is the owner of the cattle lordships. As for the cattle purchase received.
Okay, heard Mr. P. Sutia, learned counsel for the applicant, and also heard Mr. Arjay Borwa, learned additional PP for the state respondent. Apprehending arrest in connection with Sonapur PS case number 203 of 2023 under section 379 411 IPC, read section 11 A, B, and D of prevention of cruelty to animal life, read section 13(1) stroke 14 of the Assam Cattle Preservation Act. This application under section 438 services prepared by applicant Hazarat Ali for grant of periods paid. It's to be noted here that above noted case has been registered on the basis of one FIR lost by one. Lost by SI Rohit Singh of Sonapur PS on 21/9/2023. The essence of allegation made in the FIR dated 21/9/2023 is that on that day at around 1 AM, acting on the tip of, the informant has intercepted one truck bearing registration number ES02 CC9904 and found 24 numbers of cattle being carried in the vehicle without relevant documents in atrocious manner, and the driver and handyman of the vehicle managed to flee away, taking the advantage of darkness. Mr. Sutia, learned counsel for the applicant, submits that this is the second anticipated bail application filed by the applicant, and the first one being AB number 3461 of 2023 was dismissed by this court after perusing the case area on 16/11/2023. Further, Mr. Sutia submits that the ground for filing this second application is that since the rejection of the first application on 16/10/2023, more than 3 months elapsed, and the IO got sufficient time for investigation, and that the vehicle has already been given in the custody of the applicant by the learned court below, and that the applicant has also collected the relevant documents of purchasing the cattle from Bihora Weekly Market. Bihora Weekly Cattle, which will begin Buffalo Selling Market, Pukakat. And that the applicant is ready to cooperate with the investigating agency, and therefore it is contented to allow the petition. On the other hand, Mr. Arjay Borwa, learned additional PP, submits that he has received the case ID. And in view of the documents produced by the applicant in respect of purchasing the cattle, the same may be forwarded to the IO for verification, and the IO may be directed to produce the updated case diary before this court on next date. But having heard the submission of learned advocates of both sides, I have gone to the petition and the documents placed on record, and also produce the case diary with the assistance of Mr. Borwa, learned additional PP. But in view of the materials collected so far in the case diary, and also considering the submission of learned counsel for the applicant, especially the documents of purchasing the cattle by the applicant, this court is inclined to extend interim protection to the applicant. And accordingly, it is provided that in the event of arrest of the applicant in connection with Sonapur PS case number so and so under section so and so, he shall be enlarged on interim period bail on his executing a bond of rupees 50,000 with 1 security of like amount to the satisfaction of the arresting authority. The above privilege is however subject to the following 3 conditions. Number 1, the applicant shall appear before the IO within a period of 10 days from today, along with all the relevant documents of purchasing the cattle. Number 2 and number 3 say, last function shall not leave the jurisdiction of season Kamru Bank without prior permission. And the IO shall produce the updated case diary before this court on
It will be the 12th of February.
12.
Acknowledged, Lordship.
Wait, please, Your Lordship.
Yes.
My lord, there is an ad interim bail given on 6/11/23, my lord. Thereafter, the petitioner appeared on 9/11/23, and my lord, he subscribed his statement before the IO. My lord, here is a case where it has been registered under section 7A of the PC Act. But there is neither demand nor recovery, there is no voice sample, nothing, my lord. I am a police officer. Actually, my lord, the informant is an NDFB man. My lord, basically, his
No,
request
no,
was
you were in which item? Item number?
29, my lord. Govindra Rabha.
No, no, this is another matter. Kobi, what is this? What is it?
29.
I think wrong file.
Okay, okay.
Yes,
Pavindra Rava, yes.
yes. There is an ad interim order, my lord, of 6/11. And I appeared on 9/11 and I gave my statement. This informant, my lord, he is basically, he is an NDFB man. He wanted to grab a land. For that, my lord, a case was registered. Now, in connection with that, my lord, there is a request that he should be let off. When I refused, my lord, all these things have been planned. In fact, in paragraph 4, my lord, I have stated the entire background. So, lordship should kindly come to page 5, my lord. There's somewhere in the middle, the sentence starting with further. Further, the has a lordship got it, my lord. Page 5, para 4, in the middle portion.
Yes.
Further, the accused petitioner has a lordship got it, yes. Further, the accused petitioner states that Sudip Daimori, that is the informed, not informed brother, has stated that the informant is a member leader of band NDFB and will contest the upcoming assembly election. Hence, the informant had instructed accused petitioner to drop the charges against the informant, as the informant wants a clean and clear image in society. Accused petitioner had very politely refused the said proposal and had further stated that the case is already registered and is being investigated by Sub-Inspector Devesh so and so. Hence, accused petitioner will not be able to drop the charges against the informant. Moreover, the accused refused to interfere with the investigation of the case. Hence, Sudip Daimori became very angry and had threatened the accused petitioner by stated, "We will kidnap you and kill you within a week." The accused petitioner further states that on 20/10/23 at around 6 o'clock in the evening, while accused petitioner was walking near the police station, a group of 12 to 15 persons had suddenly attacked and grabbed the accused and tried to kidnap him. However, accused petitioner managed to escape from the clutches of the kidnapper. It is noteworthy to mention that Rota police station is located in a remote place, and if the miscreants can attack the officer in charge of Rota police station and try to kidnap him, then they might kill him. Hence, accused petitioner to refuse in a safe place. It was only in the morning of 21/10/23 that the accused petitioner came to know that the trap team was constituted on the basis of first information lodged by Sabon Narzari, that is brother of Sudip,
and that the trap team came to Rota police station. However, trap team was unable to meet the accused petitioner due to the aforementioned incident. So this is the background line.
No, what is the content of the FIR?
Yes. FIR is, my lord, I demanded money so that I will I'll produce the CD. But praise 20, my lord. In inviting a reference to the subject cited above, I have the honor to report that I have been endorsed to verify the complaint petition submitted by Sabam Norzari to the effect that he is an inhabitant of the above mentioned address. Sorry. Okay. Oh, I'm sorry.
This is the
Sorry,
verification
sorry, my
report.
lord. FIR is at page 15. Page 15, my lord.
Yes.
Most respectfully, I beg to state that I, Sri Sabam Narjari, son of Swayam Swayam, a permanent resident of village Dhalpara, police station Udalguri, in the district of Udalguri. I am some other local residents of Rota, as well as Udalguri had cut some trees, bamboos, and had cleared the jungles of a piece of government land which is located in Jalukbari, Rota, with an intention to construct a temple. But a person, namely Krishna Chauhan, who resides near the aforementioned land, had claimed that he is the owner of the aforesaid plot of land and had lodged a case against me and other aforesaid two person in Rota police station. On 19/10/23, I sent my maternal son, Sri Sudip Doma, to discuss about the aforementioned case with the officer in charge of the Rota police station, Govindra Rabha. He met the OC sir in the police station and OC sir had spoken with him in the police station. After some time, OC sir had stated to my younger brother that let us go outside as there is CCTV camera installed here. He took my younger brother to a tea shop which is located near the police station. It was at that moment my younger brother had asked OC sir as to what will happen to the case of my elder brother, Sabam Narjari. Then he stated that I had already told Pradip Kumar Rabha, who is a friend of your elder brother, as to what he will have to give me. At that time, my younger brother told OC sir, he had not stated anything to us. It was that moment OC sir told my brother, okay, give me 50,000. I'll take care of your brother's case. I'll send the case diary to the court. He also stated that if he gives about 60,000, then bill will be granted from the police station. I'm not in favor of paying any bribe to the aforementioned corrupt police officer. It is to be mentioned here that conversation which took place on 19/10 between my younger brother and OC sir and the statement of OC sir by which he demanded bribe from my younger brother for my bail was recorded by my younger brother in an electronic recording device, and I have submitted the said recording to the police. This is the allegation, my friend. My lord, with great respect, my lord, I think, assuming the allegation is correct, section 7A will not be affected, my lord.
Why?
But it's not complete. Merely because, my lord, and my lord, where is the voice sample? There is no voice sample. Whose voice it is? We do not know. Entire case hinges on the voice.
No, that was recorded in the recording device.
So, my lord, that has to be verified. Verified. That has not been done.
No, what is this verification report at page number 20?
Yes. Yes. Kindly come to the, my lord, first subpara. I have gone through the FIR and minutely listened to the audio recording as provided by Superintendent of Police, Vigilance and Anti-Corruption, and prepared the transcript of the relevant portion of the recording, which cousin of informant recorded while he got into conversation with the accused OC. From the clip, it is clearly audible that OC demanded bribe amounting to 60,000. That it is OC's voice, my lord, where from they got it, my lord? It can be on the basis of some surmises.
Yes, Salma?
Yes, my lord, regarding that voice sample, my lord, official report is received, my lord. Official report, my lord, according to that, my lord. As per I am reading that relevant portion, my lord. As per query two, number of audio file has been found. The audio track of the audio files, namely so and so and so and so, has been found similar to the transcript marked as the such and such number respectively. So, my lord, that is the result. That is the result. My lord,
What I'm trying to say is the transcript and the that it has to match, my lord. Where is that? Because my voice sample was not taken, my lord, to verify whether it is that of mine. And neither, my lord, they can demand unless I agree. Amendment to person to vote there to আপনার লোয়াতে আগতে এখন লোয়াতে আছে 18 amendment এর person 7 ALB attempts to obtain
Whether the voice sample of the person concerned was taken.
No, that is not clear, my lord. Actually, this is the, my lord, audio report of, my lord, conversation between the accused and, my lord, the complainant's brother. Complainant's cousin.
No, here it is open that the audio tracks of the audio file have been found similar to the transcript marked as so and so so and so. But whether that audio sample belongs to the
My lord, one thing may be done, my lord. He is on interim, my lord. Statement also recorded, my lord. May I call, my lord, the details of the FSL report, my lord?
pardon?
May I call for the honorable court may call for the details of the FSL report, my lord. He is on interim, my lord.
No, details of the FSL report means
My lord, whether the
no, whether the question is whether his audio sample was taken or not and sent to the FSL for confirmation.
that
Yes,
goes
well.
to the root of the matter.
Yes. That can be-
No, is there any indication in the case diary
My lord.
regarding collection of voice sample?
Yes,
and-
my regarding that is, my lord, I have not found, my lord. If lordship picks on tomorrow, my lord, I will go through all details, my lord.
Okay, then tomorrow.
I'll verify, my lord.
Well, lord,
Whether-
let it be after 8th of February, my lord.
8th of February.
Yes, any date after 8th of February.
If anything found,
Then up to date case ID.
my lord, after please tell me.
Mr. B. Sharma learned additional PP submits that he has received the case ID. And submits that he may be granted some time to go through the entire case ID. And also to confirm whether the voice sample of the applicant was taken and forwarded to the FSL for confirmation or not. Here Mr. Sharma is accordingly allowed. Resist list the matter on 8th of August of that, Sharma.
On 12/1.
12/1.
12/2/20. 12/2.
And on that day, Mr. Somers shall produce updated case diary before this court. Till then, interim order passed earlier shall continue.
30 and 31.
Four 38 application of the petition of Saran inside in both cases. Case diary was called for.
My lord. My lord, case diary not in receive in this both of the cases. 270, yes. 9.
You have not received the case.
Yes, ma'am.
Mr. Bisharma learned additional PP submits that he has not received the case diary. Then accordingly, it is provided that Mr. Sharma shall produce the case diary before this court on when?
Huh? Interim February. On 6th February.
6 February. Till then, interim order dated 2/11/2023 shall continue. Oh, in both the cases, you are.
Yes, yes. Ma'am.
33.
33. No, no. 33 also, my lord, I have the same prayer, my lord. We have not received the case there, my lord.
No, this is BA.
No, my lord. 33 AB, my lord.
33 Talagu to civil line.
AB. 33 Joshua.
This is NDPS case.
Yes, yes, my lord.
Oh, this is a different case.
Number 379, my lord, under section 379.
No, this is NDPS case. Number is same, but the registry has committed the mistake.
Maybe to be going.
Okay. Okay, after some time, we will bring the actual record.
34.
That is your lordship. Application under section 438. On last occasion, lordship had directed for taking steps upon respondent number 2, that is the informant, and steps were taken. An up-to-date case diary was found.
Oh, the AD has not been received.
Yes, service not completed. But steps were taken and it was received as part of.
Soba, can you confirm it from the officer in charge of concerned PS?
My lord,
You have taken a step through the
Yes, yes.
OC?
Yes, sir. But as per the knowledge of the petitioner is concerned, he has come to know that the informant's family to whom that was addressed, they have not received it. They have denied and they have stated that no, we don't have any connection with the informant. The family, the father of the informant. And maybe it has now returned back, but a report has to be there from the jurisdictional police station. So maybe if that is provided to the prosecution, then it will certainly.
my lord, here, my submission is that, my lord, FIR was lost at the Sangsari PS, my lord. But victim is resided at Orang, my lord, Udalguri district, my lord. Then they will have to take steps through officer in charge of the, my lord, Orang, my lord, Orang PS, my lord.
Yes.
Concerned PS, then victim is
It was
resided.
taken through the concern. Now, only thing is that we require the report.
No, concerned PS means if the
Means, my
victim
lord, they will have
resides
to-
at Urang,
My lord.
then you have to take a step through the officer
Urang
in
and-
charge of Urang PS.
My
Urang PS.
My lord.
You have, you have taken a step to the official in charge of Sangsari.
So then we have to again
Take a step.
take step through the Orang police station.
Orang, my lord. Then it will be clear.
Heard Mr. W. R. Mehdi, learned counsel for the applicant, and also heard Mr. B. Sharma, learned additional PP for the state respondent. Mr. Mehdi, learned counsel for the applicant, submits that he has already taken a step through the officer in search, Sangsari PS upon respondent number 2. But at this stage, Mr. B. Sharma, learned additional PP, submits that though the occurrence took place under the jurisdiction of Sangsari PS, yet the victim resides under the jurisdiction of Orang PS.
Orang PS, my lord. From
And
the
as
FIR
such,
itself. reveals.
the applicant has to take step upon respondent number 2 through the officer in search, Orang PS.
My lord.
Mr. Medhil, learned counsel for the applicant, submits that he will take fresh step within 2 days from today.
Yes.
2 days from
Yeah.
today through the officer in search, Orang PS. Accordingly, it is provided that Justice shall list the matter on
CD
first
is
week of
available, my lord.
first week of February,
My lord. CD is available.
On 8th February.
8th February. Till then, CDB retained.
My lord.
Obliged.
Item 35.
Yeah, please, madam. He was called for in this matter.
CD received, my lord.
But the FIR is at page number 18. Madam.
Where is the vernacular?
But it is in page number 19, madam.
So you have appeared before the IO?
Yes, ma'am.
When?
Around the time given to me, within 2 weeks, within these 2 weeks only I have appeared, madam.
Pardon?
Madam, specific time that I'm unaware, madam, but within the time frame I have appeared before the.
Yes.
My lord, here we have received the case there, my lord. Before the, my lord, interim order, he has appeared before the IO, my lord. And statement also recorded. Thereafter, 41 and notice was also given to him. But after interim, he has appeared on that part is not available.
As per the information, my lord, he did appear.
So this 323, 352, 427, these 3 offenses are bailable offense.
Yes, ma'am.
Only non-bailable offense is 354.
My lord.
So is there any material under section 354?
None of the witnesses, my lord, seen the offense, my lord. They have
And
heard
what is
from
the her version?
My lord, her version is that, my lord.
Yeah, heard, mister, your good name?
K. Vishwakarma, my lord. K. Vishwakarma.
Learned counsel for the applicant and also heard Mr. V. Sharma, learned additional PP for the state respondent. Apprehending arrest in connection with this for PS case number 1886 of 2023 under section 354, 323, 352, 427 ITC. This application under section 438 CRPC is preferred by applicant Suren Chanda Mili. Suren Chanda Mili. For grant of previous bail. It is to be noted here that above noted case has been registered on the basis of one FIR lost by one Ritu Pego on 27/9/2023. The essence of allegation made in the FIR dated so and so is that with the consent of Suren Chanda Mili, the present applicant, the informant was using the APDCL connection, his APDCL connection, and on 27/9/2023 at about 6:30 p.m. Suren Chanda Mili got the line disconnected, and while she interfered him, then he assaulted her and torn her clothes. As a result of which she sustained injuries on her person. The learned counsel for the applicant submits that this court, by order dated 1/12/2023, was pleased to grant the privilege of periodic bail, interim periodic bail to the applicant and pursuant to the said order, he had appeared before the IO, and his statement is also recorded. And therefore, a contention is being made that the interim order dated 1/12/2023 may be made absolute in the same terms and conditions. Whereas Mr. B. Sharma, learned additional PP, has produced the case before this court and submits that. What is the stage of investigation?
Investigation is going on, my lord, not completed yet.
Submits that the IO has examined some witnesses and the investigation is still going on. But having heard the submission of learned advocates of both sides, I have carefully gone to the petition and the documents placed on record. The case ID indicates that the IO has achieved substantial progress in the investigation of the case. Further, it appears that pursuant to order dated 1/12/2023, the applicant had appeared before the IO and he has been cooperating with the investigating agency. But having considered above and also having considered the nature and gravity of the offense, this court and the materials collected so far in the case area, this court is inclined to make the interim order dated 1/12/2023 absolute in the same terms and conditions. Case area be returned.
Mine.
38. 38.
For 38 application, the charge sheet was filed and the scan copy was called for. Yes, scan copy was called for. As per order, it is 4/1/2012 also.
R. Goswami, learned counsel for the applicant, submits that after completion of investigation, the IO has submitted charge sheet against the present applicant. Do you have the number of the charge sheet?
Yes, my lord. Charge sheet number 373/23. Date is 6/12/2023.
And as such, Mr. Goswami contended that the scan copy of the record may be called for from the learned court below. There is accordingly allowed. Registrar shall call for the scan copy of the record from the learned along with the case area from the Court of Learned Chief Judicial Magistrate Dorong.
Yes, mine.
Dorong, fixing the matter on when?
5/2/24.
5/2.
Obliged.
Item 41.
Case diary was called for.
Yes, my lord, case diary received.
Case diary is about whether notice was served.
Your lordship, notice upon respondent who has been served through the office of
Acha.
ADP and he has entered.
Acha, acha. Yes, Mr. Sharma, is there any material against
Yes,
the
my lord, why in 164, my lord, sufficient material against the present petitioner. my lord.
164?
Yes, my lord, 164.
Yes.
Yes, my lord.
Your good name?
Mr. Enigan, your lordship, may I submit your lordship?
Yes.
Your lordship, the FIR, there are grounds of this anticipated bail, your lordship.
Pardon?
There are some grounds, your lordship, in respect of this case, your lordship. The FIR has been lodged after 40 days, your lordship. And moreover, the petitioner has entered affidavit with the complainant, your lordship.
In
the content-
respect of?
In respect of this present FIR case, your lordship. And moreover, the other co-accused are on interim bail by this honorable High Court, your lordship.
Pardon, pardon?
Your lordship, there is a delay of 40 days, your lordship, in lodging the present FIR.
Yes.
And the other co-accused in this FIR have been granted interim bail by this honorable High Court, your lordship.
But he is the prime accused is the present petitioner.
Prime accused present petitioner.
And what are the other submissions?
Other submissions, your lordship, 40 villagers of the present village of the accused and the informant have given a written note, and the Gaonbura has also given a written note that the petitioner is innocent and he was framed due to some family problems, your lordship. I have
But
the-
whether they are the witness of this case? Whether they have been examined by the IO here in this
Yes,
case?
my lord, some villagers are examined, my lord. Some villagers.
Hmm.
And my lord, according to them also, my lord, that there are my lord certain quarrel between both the families, my lord. And some statement are there, my lord.
And because of the dispute, they have.
Yes, my lord, that is stated.
Actually, as per my instruction, some quarrels are going on. actually.
This side.
And they are using same boundary, lordship.
Pardon?
They are using same boundary, lordship. They are nephew and uncle, lordship, in relatives, lordship, relation, lordship. They also sworn a affidavit, lordship.
No, I could not follow.
Lordship, some disputes are going on for long times, lordship, regarding boundary dispute, lordship. They are using same premises, and as per my instruction, the FIR was lost as per their in respect of their land dispute, lordship. So
Some
FIR is
misunderstanding,
not
your lordship.
misunderstanding,
They have
lordship.
affidavit to this effect.
FIR is not correct, lordship,
FIR is?
not true, lordship. The allegation is
Which FIR?
instant FIR, lordship.
Actually, I have the affidavit into this effect.
Who sworn the affidavit?
Informant himself.
Informant himself, your lordship.
That affidavit is a part of this petition?
Your lordship, this affidavit is not part of this petition, your lordship. It was made on a later date, and in reading of the FIR, your lordship, the facts do come up. May I read the FIR, your lordship? There are terms like Fu Mimankar, Sumazor, Babe Fu Mimankar, and all these terms are written. There is a column in FIR. All these things are given in the FIR itself, your lordship. At page number 17. Plain reading of the FIR, your lordship. Things do clearly come out.
But 164, my lord, is specifically created.
Lordship, moreover, Supreme Court has given direction in one case, your lordship, 164 has to be recorded after 24 hours of the incident, your lordship. And there is a delay of 40 days, your lordship. This is just my
my submission, Your Lordship.
So that direction will come into effect after losing of the FIR. No. So, yes, you file an affidavit then? Yeah. We'll see.
Till then, your interim, Your Lordship, considering these facts.
Oh, allegations are serious. The statement of the victim girl is recorded under section 164 CPC.
If annexure 3 and 4, Your Lordship may kindly produce. I have given in para number 4 of the petition, Your Lordship. Page number 6, para 4. Para 5, page number 6.
Yes, FIR is at page number.
Page number 17 of the petition. 17, Your Lordship. May I read?
Let him file a affidavit. Will no. Heard, Mr.
A. Iqbal.
Learned counsel for the applicant and also heard Mr. B. Sharma and Mr.
R. Islam Lordship.
R. Islam, learned counsel for the respondent number 2. Mr. Islam, learned counsel for the respondent number 2 submits that he will file an affidavit in this application. Accordingly, it is provided that Mr. Islam shall file a affidavit on when?
Within 1 week, after 1 week.
After 1 week. Till then, case diary be retained. Next item.
Item 44, 42. Item 42.
That is your lordship. My lord, the matter may be adjourned, my lord. I should file an additional affidavit, my lord. Connected documents I am obtaining, my lord. Very relevant,
Yes,
my
yes,
lord. So after 2 weeks, it may come.
It would. Mr. A.K. Talukdar, learned counsel for the applicant, submits that he may be granted some time so as to enable him to file an additional affidavit. Where is accordingly allowed, no, so as to bring on record some documents.
My lord.
Some documents. Where is accordingly allowed, rest is the matter after 2 weeks.
Date may be fixed.
On 9 February. Item 44.
Time period, lordship. Lordship, this is 438 bail application under section 379 and Cattle Preservation Act. Lordship, affair is page number 12.
This is the second application,
No, lordship.
first application.
Yes. May,
Yes,
may I read the affair?
at page number,
12.
yes.
In closing here with the above GDE, I have honor to state that on 4/12/2023 at about 9 p.m. I along with staff left for Naka checking duty at Jurapad, Ling Road, Assam Meghalaya border point. During performing Naka checking duty on the above noted place at about 9:30 p.m., two numbers of vehicles bearing registration number so and so coming from Nagaon side towards Meghalaya has been intercepted. When the vehicle checked, found that the vehicle was loaded with cattle and the driver of the vehicle carrying the cattle atrociously from Nagaon side to Bornihat, Meghalaya. Accordingly, says the vehicle bearing registration number so loaded with 12 numbers of cattle and vehicle bearing registration number so loaded with 10 numbers of cattle in presence of witnesses as per seizure list and apprehended the driver of the vehicle number so namely Dildar Hussain, son of Hassan Ali, village so and driver of the vehicle number so namely Abu Taleb, son of Taib Ali, village so Nagaon district. The apprehended driver of the intercepted vehicle stated that they brought the loaded cattle from Nagaon towards Bornihat, Meghalaya, but they could not produce any valid permit documents of competent authority in support of loaded cattle, and also failed to produce veterinary certificate of the said cattle. It is suspected that they smuggling stolen cattle.
Okay, all right. Mr. Sharma, you received the case.
Yes, my lord.
Lordship, kind.
Is there any material against you? Who, by the way, who are you?
I am the owner of the vehicle.
Which one?
Registration number AS12CC 3029.
So why you were apprehending arrest?
Lordship, kindly come to the page number 5. Point number 4. The petitioner begged to state that the main accused already. Lordship, page number 5.4. The petitioner begged to state that the main accused already released on bail by the learned court below on dated 3/1/2024, and Zimba was also allowed by the learned court of SDGM 2 on dated 2/1/2024, and I am the owner of the vehicle by registration number so, but I cannot approach the IO of Boishisto Police for Zimma of my vehicle due to apprehension of arrest. Lordship, I have the Zimma order and a case reference which is passed by this honorable court.
Yes, Mr. Sharma.
My lord, two driver, my lord, they were arrested. And my lord, they mentioned about some
my lord, trader of my lord, Ethel. Name also not mentioned. This is my Guru Bepari. And my lord, the names of my lord not figured in the entire case there, my lord, the present petitioner. So my lord, his apprehension, my lord. It is.
And
Okay.
section
Lord Mr.
370,
Your good name?
M. Hussain.
M. Hussain, learned counsel for the applicant, and Mr. B. Sharma, learned additional applicant for the state respondent. Apprehending arrest in connection with process of PS case number 758 of 2023 under section 379 IPC, reduced section 11(1)(d) of the Prevention of Cruelty to Animal Act 1960, reduced section 13(1) of Assam Cattle Preservation Act. This application under section 438 services preferred by applicant Ikram Ul Hussain for a grant of arrears bail. The above noted case has been registered on the basis of an FIR lodged by SI Sinmay Barua of Zirabad Outpost, Police Outpost on 4/12/2023. The essence of allegation made in the FIR dated so and so is that on 4/12/2023 at about 9:30 p.m. he has intercepted two vehicles bearing registration number AS12CC T029 and AS02 DC3766, which were coming from Nagaon side towards Meghalaya, and during search of the vehicle, he recovered 12 numbers of cattle loaded in vehicle number AS12CC T029 and 10 numbers of cattle in the vehicle bearing registration number AS12CC T029, and also apprehended the driver, namely Dildar Hussain and Abu Talib. Who have stated that they have brought the loaded cattle from Nagaon towards Barnihat. The learned counsel for the applicant submits that the applicant is the owner of the vehicle bearing registration number AS12CC T029, and that he is no way involved with the offense alleged in the FIR, and that he is innocent, and the said vehicle has already been released in his custody by the learned court below, and that he is ready to cooperate with the investigating agency, and therefore it is contended to allow the petition. On the other hand, Mr. B. Sharma, learned additional PP, has produced the case before this court and submits that nowhere in the case diary there is any reference of the present applicant, though he has been apprehending arrest here in this case. Having heard the submission of learned advocates of both sides, I have gone to the petition and the documents placed on record, and also perused the case with the assistance of Mr. Sharma, learned additional PP. In view of the materials collected so far in the case area, and also in view of the submission of learned advocates of both sides, as well as the nature and gravity of the offense and the punishment prescribed for the same, this court is inclined to allow this petition, and accordingly it is provided that in the event of arrest of the applicant in connection with process of PS case number so and so under section so and so, he shall be enlarged on interim pre-arrest bail on his executing a bond of 50,000 with 1 security of like amount to the satisfaction of the arresting authority. The above privilege is however subject to the following three conditions. Last condition, shall not leave the jurisdiction of CJM without prior permission.
Timing 57.
Published.
In this case, Lordship, earlier it was fixed on 22/1/2024, Lordship, for the production of the case diary. We have got the information that FR has been submitted, Lordship.
FR.
FR.
On the ground of?
My lord.
On what ground?
And final report submitted, Lordship. Not
On
subject.
what ground? Due to mistake of fact or due to absence of material?
That has not been mentioned, only my lord, we have been forwarded the my lord, before that my lord, FR has been submitted.
This application under section 439 services preferred by accused Monwar Hussain, who has been languishing in jail Hazut in connection with Govardhana PS case number 138 of 2023 under section 457 T80 401 IPC. It is to be noted here that above noted case has been registered on the basis of one FIR lost by one Abdur Rahman on 21/9/2023. Mr. Borua learned additional PP submits that by order dated 5/1/2024 and 11/1/2024, the case diary was called for, but he has not received the case diary. Instead, he received an instruction that after completion of investigation, the IO has returned the case in FR. In view of above, this petition become infractious and accordingly the same instance closed. The accused shall be released from the jail Hazut forthwith if not warranted in any other case.
The FR number was 26.
FR number?
FR number 26 of 2023.
26
dated
of
2023.
20?
26 of 2023.
23. Dated?
Dated 31/12/2023. 31 December.
Timing item 33.
Just to change.
Hmm.
Please, Your Lordship, I'm appearing on behalf of MOC.
My lord, in this, my lord, yes, my lord, wrong item has been, my lord, case has come, lordship, because my lord, item number 33 AB 3934 and name of the party is my lord Raju Kathar, lordship, in the causes. But my lord, the record is different. So then we have to go to the LCR, lordship. We have not gone to the LCR.
Lordship, my application under already get an interim bill, so make 14. Answer to the line of section report.
LCR to call করা গৈছিল নাই? Okay, Mr. RJ Borua allotted additional PP submits that he may be granted some more time to go to the LCR. Here is accordingly allowed. List the matter on when? 23rd, till then interim order dated 22/11/23 shall continue.
Timing item 13.
May I please look to the NDPS case, lordships, the today is lordship 482 days, lordship. Earlier order.
This is commercial quantity?
Commercial quantity. 40.385 kg.
40?
40.385 kg.
Ganja?
Ganja. Till that, no production of the no witness was examined. Till that.
Mr. Borua, have you gone through the record?
Yes, my lord. My
So,
lord,
search was framed against the
search
accused?
frame, yes, my lord, on 23/8/2023 search frame.
23?
23/8/2023. Search frame lordship under section 20B2C and 29 of the NDPS Act. After lordship, the case was fixed, my lord, for the production of the witnesses. But no witnesses examined till date. Last date was fixed on 14/11 as per the status report.
You are behind the bar for how many days?
482 days.
What is this?
This lordship order this order lordship paragraph 21 lordship, same category of case lordship. Paragraph 21. Onwards 21 lordship, 22, 23.
That's all right, but you have to see what is the ground for delay and who is responsible for the same. Hmm? In the case of that Muslim Mandal, no, Mohammed Muslim, he was behind the bar for 7.5 years.
Yes.
Yeah. And there the court has considered section 436A.
There also by virtue of section 37, my lord, of the NDPS, the person cannot be kept behind the bar for non-examination of the truth. In Mohammed Muslim case.
Mohammed Muslim case, Rabi Prakash.
Hmm.
It was. Any condition lordship, length of credit lordship, any condition. I face the trial.
Any condition means how the judgment of Supreme Court in this Mohammed Muslim case will help you. Hmm? How the ratio of that case will applicable in the case in hand.
The up to date status report will call for notice. Because it is up to 14th of November. After that notice, there may be some status exam. After 14th of November.
Okay. As agreed by learned advocates of both sides, registry shall list the matter in the first week of second week of February.
On 12th February.
And in the meantime, registry shall call for up to date status report.
Lordship, the party has informed me, lordship, they withdraw this petition, lordship.
They want to withdraw?
Yes.
Okay, all right, you can withdraw the petition. Later on, Mr. Ahmed, learned counsel for the accused, submits that the accused want to, no, he has been instructed by the accused to withdraw this petition. Here is accordingly allowed. This be a sense of disposal on withdrawal.
Item number 45 for orders.
This IA is for what purpose?
My lord, I am representing respondent. If lordship allow me, I will make the position clear. My lord, the IA is filed for condonation of delay by the petitioner. My lord.
Condonation of?
Delay. My lord.
Yes, you are for respondent.
I am for the respondent, my lord, key respondent. Now, lordship, the facts of the case such that, my lord, just for the purpose of
No, so this is an application under section 5 of the
my lord, limitation
Act. So what is the amount of delay?
My lord, the delay itself is a confusing one, my lord. Lordship, just I am placing the facts, my lord, then it will be helpful to know whether the condonation of delay, the days are correct or not, my lord. My lord, I have supplied certain articles, my lord, to the petitioner, my lord. Now, based on that, my lord, they have issued a check. The check was dishonored. Once the check,
This 341 days. This was counted by the
my
registry.
lord, they have counted the days from the date.
No, registry has counted it.
340 days they have counted.
Mm.
But lordship, the date which they have counted, is from the date where this honorable court passed already an order in a revision petition. They have not counted the day from the date from where the order passed in criminal appeal matter. Lordship, just only 1 minute time, Lordship. I will make the clearly the facts. Then I think it will help to my lord understand the facts correctly. Now, my lord, once this my lord NI Act was order was passed in my favor, they filed an appeal. That appeal was also dismissed. Once this appeal was dismissed, my lord, they approached before this honorable court by way of revision petition, my lord. That revision petition was also dismissed, my lord, because of the non-compliance of the conditions of depositing 20%. Afterward, my lord, once this revision petition was dismissed by this honorable court, now this is the second revision petition. Therefore, my, this is a revision petition.
Earlier petition was not a hardened merit.
My lord, question doesn't arise for hard on merit because, my lord, it is a condition which they failed to comply with. Therefore, once this condition failed to comply, the revision goes, my lord. Once this revision goes, my lord, it reaches, my lord, finality. Res judicata attracts, my lord. Lordship, just look for a moment, my lord. Page 60.
In criminal cases, res judicata applies.
Absolutely, my one issue is been decided that cannot be reopened, my lord. It is a decided case.
No, that was not decided on merit.
My lord, once there, my lord, fulfill the condition imposed by this. Lord, just look for a moment, my lord. Page 40.
So, where is your senior, madam?
So, for another court.
So, can you argue the matter? No.
We need time.
Okay.
For one week. Here's the.
On the pair being made by, what is your name?
H. Devi.
Ace?
Devi.
Learned counsel for the applicant, list the matter after a week.
My lord, only one humble submission. My lord, because of the pendency of this criminal petition, my lord, my payment has been, my lord, stagnated at my lord lower court. Lord, you kindly fix a short date, my lord, possible.
Okay, 1 week.
Next.
Next week, my
Next
30, 30.
30.
Item 46.
My lord, similar.
May I please, your lordship? In the IA, your lordship, this honorable court directed by order dated 13/12/23 to take steps for the concerned PS police station, but we could not take it on time, so we may be allowed to take steps.
Your good name?
M.R. Sadiq.
Sir M.R. Soryat, learned counsel for the applicant, submits that he could not take a step upon the respondent.
Number 2.
Respondent number 2 within the stipulated period, and therefore he prays for granting him some more time. Pair is accordingly allowed. List the matter on when?
After a week,
After a week.
deeply obliged.
Item 47.
Have lordship. Lordship, IA for vacating the stay order, lordship. Order dated 2020, lordship, please to pass the order, lordship. So, lordship, whatever, lordship, the relevant part is page 20, lordship. I'd like to say from the one aspect, lordship. Page 20, lordship, is the bottom portion, lordship.
That order is at page number?
Page number 21, lordship.
Page number?
Page number, sorry, 19, lordship.
19.
19, lordship. Lordship, please to pass the order, lordship. Lordship, relevant part is page 20, lordship. Is a bottom portion, lordship. Merit, lordship. Is a last 5 line, lordship. The bottom portion. Wherein the land magistrate has issued only notice to the petitioner, but on 10/6/2023, the IO had issued one notice to the petitioner by restraining him from the doing any kind of activities in the dispute lands till disposal of the MR case 66 of 2023. Mr. Swenson submitted that there is no order of the Lanet district magistrate, lordship. So, lordship, here, lordship, the wrongly submitted, lordship. So, lordship, kindly find now the order dated 7/6/2023, PS 24, lordship, Annex 3, lordship. PS 24, lordship.
Page 50?
24, lordship, 24.
Yes.
The proportion, lordship. Here clear defined, lordship. The forwarded to the OC Murazhar PS to stop this kind of activities in the dispute plot and submit report, lordship. Lordship, first paragraph, Lordship. Here, Lordship, the humble application first party begs to state that the aforesaid MRKs has been going on before the land court as per under section 145, 146 and oblique 107 of the CRPC. During the pendency of the said litigation, the second party forcefully held boundary wall and cultivate over the dispute lands. If it would have obstruct upon the second party by the first party, then the sequel, the imposed threaten as well as the dire consequences. So the concerned officer in charge, the Muzar police station, kindly be stop second party activities over the said disputed land, Lordship. Lordship, as per the direction, Lordship, by the additional district magistrate Huzai, Lordship. So thereafter, the police has issued the notice, Lordship. Notice, Lordship, page 22, Lordship.
Page?
22, Lordship.
No, the submission of the learned counsel for the petitioner was that
Without any order of the
you saw the order. Where is that order?
Lordship, the page 24 just reflect, Lordship. The
24 is a notice.
the forwarding
No,
report,
it is a petition. Is it a part of order?
Yes, Lordship. It is a forwarding report to the police concerned, Lordship.
No, 24 is a police report.
Yes, Lordship.
No, where is that order?
Lordship, 24 is the order pleased to pass by the additional district magistrate, Lordship, Zai, Lordship. The page 24, Lordship, the forwarding report, Lordship,
Forwarding report by
the additional district magistrate, Zai, Lordship.
to the
Police concerned, the Muzahar police.
Hmm.
The order dated, Lordship.
No, what was the submission of the counsel for the petitioner?
So they have wrongly stated that without the direction of the ADCM, the police cannot be issued the notice, Lordship. The brief of the I like to set out the fact of the case, Lordship. So here in this case, Lordship, the petitioner is a wrongly submitted this application, Lordship, the quashing 482, Lordship, in the police or notice, Lordship. So the annexer 4, 5, and 6, Lordship, is a cell deed which is absolutely wrong cell deed, Lordship. Can you see the Lordship, the quashing petition, Lordship, filed by the petitioner?
So, where is your senior?
Sir, my senior has gone for some urgent meeting.
Pardon?
For some urgent meeting.
He left the court.
Sir, MU Mahmood.
No, your counsel, no, your senior left the court. So, let us fix another
Yes,
date, let him remain present.
Yes, Lord. Yes, sir.
So, as agreed by learned advocates of both sides, list the matter on suggest one date.
Lordship of
When? Okay. 6 February. Okay.
Yes, sir.
Item 48.
May I please, Lordship? 48 is a IA, my lord, and a connected criminal petition seeking, my lord's stay of a proceedings. The petitioner before Lordship is an advocate. He had an altercation with admittedly some alteration with the informant. And there was some exchange of some heated sentences. Lordship will find that at page 21, the FI starts. And what he said is at page 22 is in bold, my lord, in black bold. In fact, my lord, everything was agitated before the learned judge, my lord, learned court, my lord, who had taken up that criminal petition, my lord.
Let notice go at the system.
No, in that case, notice is already gone, my lords.
Where?
It is connected to the criminal petition, my lord.
No, you have not taken any step.
1378. But since, my lord, it's the entire edifice of this case is, my lords,
complaint was filed, and my lord, it was FR, and then my lord, Narajinama was filed. Then my lord, the police, my lord, re-examines the court directs that you further investigate without recording any reasons. Then again, my lords, based on 161 statement, my lord, which is hit by my lord, section 25 of the Evidence Act. He says he confesses his guilt, so you are being charge sheeted. And Miss, my lord, since it concerns with the petition before your lordship is my lord, advocate, my lords, I seek my lord, I pray my lord, the proceedings may be stopped, my lord. Because my lord,
No, merely because the applicant is an advocate, we cannot state
my
of
lord,
this.
I'm not pressing on that. In that case, on merits, my lord, kindly see the charge sheet, my lord. Kindly the charge sheet. Charge sheet, my
No,
lord.
but in the main petition, notice has already been issued.
So my
No,
humble place, my lord.
no, order for issuance of notice was passed.
Yes, yes.
But you have not taken any step.
The steps I will take, my lord. What
Oh,
will
no,
happen?
no, no.
Yes, proceed. No, steps I will
You
take.
say office note dated 10/1/24 indicates that no step for issuance of notice upon the respondent has been received by the section till date.
Steps, my lord, will take, my lords, vacations should ensue, my lords. So we'll take steps by today itself or tomorrow itself. My lord, my humble base, my lord, pending this application, my lord, any further proceedings may be stopped. My lord.
No, let the other side enter appearance.
My lord,
Thereafter, we'll
section
consider.
merely 294, my lord. There was no exchange of any public, no public and annoyance was conducted, my lord. Nothing was there. Only some exchange of words were there, which we admitted. But my lord, the 294. there's
No, we cannot enter into the merit of the petition at
my
this
lord,
stage.
since my lord says IA, my lord, seeking a specific stay pending that criminal petition.
Mr. Barua?
My lord, since it's already directed to serve notice upon the respondent number 2, lordship. Because lordship, her appearance should be, his appearance will be my lord necessary, lordship. Because it's a quashing petition, lordship.
Well, I am not praying for that. I should be allowed washing on the first day itself. So my only this today itself it was also fixed for appearance, my lord. So pending this petition, my lord, will keep this at least us till next date, my lord. Till next date, can it be, my lord? Stay.
No,
It's a specific IA for only for
but
passing.
hearing the other side, it will be difficult to pass the.
Because it's 294, my lord.
You take a step upon the other side.
That I will take dusty, my lord. That I can undertake, my lord. But my lord, today it's not the date for appearance, my lord. And my lord, I also, if lordship allows, I have a citation in my hand which says when 294 comes into play. In
No,
this case,
that
we are
will
not
be
entering into
considered
merit.
at the time of hearing. Third, Mr. D. Gogoi, learned counsel for the applicant, and Mr. R.J. Barua, learned additional PP for the state respondent. This interlocutory application is filed by the applicant for staying the further proceeding of DIFU PS case number 343 of 2021 under section 294 IPC pending before the Court of Judicial Magistrate First Class, Karbi Anglong at DIFU. It appears from the record that in the main petition, filed order dated 22/12/2023, notice was issued to the respondent number 2, but office note dated 11/1/24 indicates that no step has been taken upon respondent number 2. So let notice be issued, Peda. Let notice be issued to the respondent number 2 by registered post and also by usual process, and also through the officer in charge jurisdictional PS. Returnable on sorted. Returnable on 1st of February.
Some interest may be given because my lord, today was also date fixed for appearance.
And that's all right. Let notice be served upon the
Notice I
respondent
can
number 2.
undertake, my lord. I can go for dusty also, my lord, but till then, my lord, let something be some intermediate, my lord. It's matter because it's appearance upon appearance been directed, my lord. And
that's all right. You take a step.
My lord.
You file a petition there that case is pending before this court.
My lord, in that case, can be status quo, my lord. Till dusty.
No.
Otherwise, my lord, this IA is IA, my lord, does only lengthens my anxiety, my lord, nothing else.
Merely because he is an
Sounds like
advocate,
it, my
we
lord,
cannot
because
grant a relief.
294 minus nothing has
Maybe
come. And police has
294
based,
is
my lord,
also an offense.
police has based this charge sheet only on 161.
which is not admissible also, my lord.
161.
161, my lord, see.
No, only on the basis of 161,
They have taken
police,
yes, my lord, they
police
have taken
filed the
the
charge
case,
sheet.
they have filed charge sheet, which is not admissible, my lord. There is hit by section 25, my lord, evidence
Hmm.
section.
No, usually all the statement under,
151, my lord.
yes,
But
then,
he re-examines the complainant and informant both, my lord.
hmm.
And my lord will see the learned learned judge, my lord, who passes that you investigate, he doesn't apply mine. There's no indication he applies mine. Why that further investigation is given, my lord?
Okay, we'll see.
I'll see you at page
Next,
25.
that no interim relief at this stage.
My lords.
49,
My lord, in that case on a date,
1st February.
first February. Always, my lord.
49,
None
My lord,
appears for the
petition, my
applicant.
lords, that my lord had just given one observation that I can file some petitions. But some one line may be given, my lord.
File petition
Lower court
for?
may be apprised, my lord, that the petition is pending.
No, 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 that observation cannot be there. No, it is verbal.
49,
Always, my lord.
49,
None appears for the applicant on call.
item number 54 hearing.
List the matter after 1 week.
Equilegous conviction, your lordship. Equilegous conviction, your lordship. So, 8 witnesses are there, your lordship. It will take some time, your lordship. Can we maybe give it?
As grateful by learned counsel for the appellant, list the matter on when?
On 1st February.
On the next date, your lordship.
First,
Not
on 1st February.
Not on first, on any other date.
On 6th February.
6th. Publish your object.
Item 51.
Please, your lordship. But here in this case, my lord, on other day, your lordship refer me to GP Singh, my lord. So, my lord, my humble submission before your lordship, Gyan Singh, my lord. So, on the basis of the Gyan Singh, my lord, I will humbly submit before your lordship that in Gyan Singh, my lord, sum total it is say that the offense may be non-compoundable. In that case also, in section 482 petition, the High Court can look into if it is compromised by the parties. Supposing there is a difference between section 320 of court's jurisdiction, compoundable and non-compoundable, CRPC. But in 482, it may be non-compoundable. If the party compounded.
No, that's all right. That is the settled position of law. But the question
thing
is
is,
whether
if the
a
case of
charge under
Dakati-
section
in the case of
376 can be
Dakati,
passed.
Rape, heinous crime, my lord. But present case, my lord, there is no case of rape, allegation of rape is not there, my lord, only 67A of the
No, but in her statement, the victim has categorically